Mr. Johnson, we were at page 287 of Bundle 1. We were about to deal with the meeting of the 30th of May 2018 from paragraph 5.8.82 onwards. Could I ask you, please, to refer to the source document for this portion, which is at page 589 and following in Bundle 1, 589. Are you with me, Mr. Johnson?
Yes, I am.
What we will see from the heading is that this is the PMG report on a meeting of the Portfolio Committee on Mineral Resources and Energy, dated the 30th of May 2018, on issues pertaining to Optimum Coal Mine, Shiva Uranium Mine, Lily Mine Progress Report, and the State Capture Inquiry Program. And if I could then take you to page 593, where we see the portion of these minutes which refer to the inquiry into state capture at the Department of Mineral Resources. Bundle 1, page 593. Are you with me?
Yes.
Chair, may I just check that you've had an opportunity to find the reference?
You said 593?
593, that's correct.
Yes, I am at 593. Thank you.
Thank you, Chair. Now, you will see that under that heading, the introductory portion is a report back from Ms. Fatima Ibrahim, the Parliamentary Legal Advisor, who is recorded as saying that at the last meeting, the department had indicated that they had set up preliminary meetings with potential witnesses to try and garner more evidence. Some were in response to submissions and others involved persons that the support staff had identified. The support staff had been due to travel over the weekend to conduct those interviews, but late on Thursday afternoon, they had been informed that their travels were not approved. As a result, the trip had not taken place and they had not been able to meet with the relevant witnesses. And it continues, I quote, "It appeared that this may have been due to budgetary issues which led to two problems. The first was that a budget was needed to conduct the inquiry. The department was not based in Cape Town, and the majority of the relevant people were not based in Cape Town either. Travel was therefore by no means a luxury, but rather something that was necessary, because it would not make sense to ask witnesses to come to Cape Town as opposed to three people from the support staff going to Johannesburg." This is what you were referring to a little earlier, is it not, Mr. Johnston?
Yes, that's right.
And then Ms. Ibrahim continues, "The second issue was that in the absence of those meetings, the support staff had been thrown off their work schedule, as they were dependent on those meetings to assist them to close the gaps that they had identified in their research and to start preparing their questions. She had prepared questions for certain witnesses, but needed input from those potential witnesses." And she continues. And then the minutes record in the second paragraph of page 594 the following, under the heading discussion. "The chairperson said that he had met with the House chairperson," that would be Mr. Froelich, "and in the discussion it had been indicated that no money was allocated for issues of oversight. The other issue was that with the schedule they had, no arrangement had been made to have a member remaining behind to do this unless there was a very strong motivation beyond legislation. Thirdly was the issue of a cost exercise where the starting point would have been to call the new executive, and establish where the work was being done on the basis of what had been presented to it." And so it goes. So basically, what is being reported is that nothing can happen because no money has been allocated to oversight. Is that your understanding?
Yes, it is. And that wasn't communicated directly to us That's something that we only came to understand afterward, but I'd just like to digress here because this is something that falls quite squarely in our mandate as an organization. And we've analyzed the financials of Parliament, and I'd like to highlight that this institution gets about 2 billion rand of taxpayers' money per annum. And the vast majority of that money goes to the facilities and travel expenses of MPs. So the suggestion that there is no money for oversight is quite far-fetched.
I'm sorry, Mr. Johnston, you say the bulk of that money, if I understood you correctly, goes to traveling by MPs and what else?
Chairperson, it's a range of things, and we've tried to really dissect exactly what it's used for, but it's not so clear. What we've come to understand, we were trying to understand the funding of constituency offices, because the Joint Standing Committee on the Financial Management of Parliament has issued several reports saying that even though money is consistently being allocated to those offices, there's no clarity on whether they operate. And in some instances, there's no clarity on whether they even exist. But political parties are in control of those budgets. So we've tried to get more information on exactly where the bulk of this money goes, but it's not immediately clear. And now we're waiting for political parties to tell us exactly what they do with that money.
And I think you did
sorry. Sorry, Mr. Freund. Is your point, Mr. Johnston, that you haven't found anything to suggest that there was money that had been allocated for oversight but wasn't used? But your point is that yes, it was not allocated for oversight, but they could have taken money from somewhere, from some items, and allocated part of it to oversight. Is that your point?
Yes, Chairperson, the latter is my point exactly. And
Okay.
in the budget's breakdown, as we see it, there's no dedicated chunk of money that goes to oversight, but there is very substantial chunks of money that's dedicated to the personal luxuries and facilities of members of Parliament. And we believe that that's the sort of money that could very easily be reprioritized for this sort of expense, but that wasn't the case.
Okay. Mr. Freund?
Thank you, Chair. The minute continues, quoting Mr. Lorimer, an opposition MP, who said that this was unacceptable because why would Parliament want an inquiry? And bear in mind that this was the mandate that they had been given, and then not allocate a budget. The committee needed to write to Parliament and request that a sufficient budget be allocated. And that's really where the matter stood. Am I correct?
Yes, that's exactly right. And I would like to point out one more thing, and that's that the support staff here and even senior legal advisors indicate that they are dependent on external sources of information. And I have had some direct contact with many staff members like this, and they've indicated that when it comes to a point where they are on the verge of getting very useful and important information from external sources that are obviously apolitical, that they would be prevented from doing so, because that would obviously expose issues that politicians might not want to have exposed.
We've been deep. Sorry, Chair.
Yes, can I just ask this question, Mr. Johnston? For members of Parliament to perform effective oversight, they need to have relevant information to be able to ask pertinent questions to the executive. And to do that, they might need persons who could do some kind of investigation prior to them having a meeting with a minister or DG or a board of an SOE. For example, if there are allegations that are in the media that fall within, that relate to a department or an SOE, which accounts to that committee, I can imagine that if a committee immediately said we want to see the minister before there was some homework that had been done, they might not really be able to ask proper questions or challenge whatever the minister tells them. It may be that they need people, I guess some of them might be lawyers, some of them maybe might be accountants, I'm not sure, who could go and interview witnesses and collect affidavits or statements or collect whatever information and make sense of the information in a document that's given to the members so that they can then ask proper questions. Now, I don't know, I suspect that researchers don't do that because I understand they've got researchers, even though maybe they might not be adequate. But people who could go to ESCOM, Transnet, when there are issues that the portfolio committee is interested in, interview people, and the people at ESCOM would be obliged to cooperate, or people at Transnet would be obliged to cooperate, give those people who are employed by Parliament to all the information. Are there people like that that are available to various committees, or is it only the researchers?
So there are content advisors. I think each committee has a content advisor, but in Parliament there's a small group of legal advisors, and I think the number is 11, and the number of committees they serve is 40. So obviously they are at a disadvantage in terms of the workload. But an important point that I want to make as I go towards the end, Chairperson, is it need not be something that's financed by taxpayers. There are many civil society organizations like us who are sources of external capacity and information that would love to provide this sort of assistance to these committees. And we made our availability and willingness to do exactly that very clear when we engaged with the committee secretary. And we were on the verge of having an entire day meeting to do exactly that. But when the, one can presume the chairperson and members of the committee came to understand that this is what is going to happen, they made the decision that resources cannot be allocated to that. So another important point, I think, to appreciate in this commission is that the members of Parliament seem to have complete discretion, and they can completely arbitrarily decide on what money should be spent. And when it comes to their salaries, which are exorbitant in my opinion, there's never a question of whether there's enough money. There's always enough money for that. But when it comes to oversight, there's not necessarily enough resources. And I think that's just illogical, Chairperson.
Okay, thank you. Mr. Freund?
Thank you, Chair. Now, we've been dealing with a meeting on the 30th of May 2018. The next date that you referred to, which is at page 289, is the 12th of September 2018, which is quite some months down the line. And you refer to the meeting on that date of the Portfolio Committee on Mineral Resources. You say that was the last time they met with a focus on the allegations of state capture, and you refer to Annexure 5.5. And then all the way through to page 297, you deal in some detail with what happened at that last meeting. But I'd just like, for present purposes, to jump to the end, which is at page 297, paragraph 5.8.101. And there, at the end of that paragraph, you say the following, and this is reflected in the source document as you finished. The chairperson said that members were proposing that the committee write a letter requesting a decision from the House Chair, that is to say, Mr. Froelich, on the budget to be given, while still continuing to seek clarity on the status of the 4 areas that it had requested. You deal with that earlier in the affidavit. The members agreed and the meeting was adjourned. And then you continue in the next paragraph, the inquiry was never carried out. So is that really the end of the story?
Yes, it is. And we tried to get an explanation from the committee staff who we had engaged with before as to why this was no longer going ahead. But they just didn't answer us. And I presume that's because it was not their decision. And they had probably been told not to relay any explanation because no explanation could be justifiable. But that was the end of it.
So let's just go back and let's just look at some of the highlights of that meeting, which we know how it ended. Let's go back to page 289, paragraph 5.8.86. What we see in the second half of that paragraph is that the parliamentary legal advisor, Ms. Ibrahim, had been instructed to prepare a draft budget in consultation with the committee secretary. They'd done that. But up to this point in time, 12 September 2018, there had been no indication whether it had been approved, and so no further work had been done. However, there had been, in the previous 3 months, some developments, and so they looked in the course of this meeting at some of those developments. One of those is the minister had told the committee, this is now a new minister, I take it, had told the committee that the department had taken certain steps to address corruption. And there was a reference at the top of page 290 of your affidavit. Further, the Zondo Commission had started looking into allegations of state capture, which is to say, I think the legal advisor, believed would be related to the former minister, Mosebenzi Zwane, and the commission enjoyed benefits of sufficient resources, technical expertise, and investigative capacity. And so the suggestion was then made at the end of that subparagraph that I've just been reading from, that the committee may wish to review the terms of reference and to narrow the issues down. And so there was then discussion in the course of this meeting of a more limited inquiry. And what I think you've told us is that effectively even that did not happen.
No, it did not. We had sight of those revised terms of reference, and they were quite specific. So I believe it wouldn't have taken a lot of resources to carry out that exercise, but that's the way it was presented.
So let's just sum up where we've got to. Mr. Froelich has signed a set of letters in June of 2017 to the chair of this committee, amongst others, saying it's an urgent necessity to investigate and report back into allegations relating to alleged state capture. Here we are, a year later. The committee is frustrated by the non-cooperation of the minister primarily accountable, wishes to proceed with an inquiry, makes that very clear, so the documents indicate, and no inquiry at all takes place. Is that the summary in a nutshell?
Yes, that's it. And in the meantime, I think it was Dr. Koza who referred to the recycling of failure. What had happened was that Mr. Zwane was then replaced with Mr. Mantashe as the minister. And suddenly there was no more interest to speak with Mr. Zwane, simply because he was no longer in that position. And this is something that happens very frequently. We've seen it in state-owned entities, in municipalities, in provincial government, and in departments. It happens all the time that when someone becomes tarnished, with allegations that have not been resolved. They simply shifted to a different position in the hope that that issue would be forgotten. But that's basically how it ended.
Where did Mr. Zwane end up?
Excuse me?
Where did Mr. Zwane go?
Immediately afterwards, I'm not sure, but I know eventually he was appointed as the chairperson of the Portfolio Committee on Transport, which is where he is today.
I think he isn't. I think he was not appointed to President Ramaphosa's cabinet at the beginning of 2018, I suspect. Is that your recollection as well?
Yes, Chairperson. The majority of tarnished ministers
Yeah.
that I deal with in the affidavit as well were sent to Parliament. And it's a point I wanted to get to, is that Parliament has become kind of like a cooling off zone for tarnished politicians. So even though they didn't feature in cabinet, they were still at the very top of the political party list. And they ended up as chairpersons of committees in Parliament. And I think their salary today is 1.4 million rand per annum. And that's paid for by taxpayers.
Yes. Mr. Freund?
And you deal at the top of page 200. I'm sorry, Chair. May I proceed?
Yes, you may proceed.
Thank you, Chair. You deal at the top of page 298 with an issue you've already referred to, the budget of Parliament. And you say that Parliament receives no less than 2 billion rand per annum from the fiscus to finance its operations. Is that correct?
Yes, that's correct.
And it's a matter, well, let me withdraw that. Now, I'd like to move on and deal briefly with certain other streams of inquiry. You deal with the PRASA issue from paragraph 5.8.114, which is at page 300 of bundle 1. And you deal in particular with a meeting on the 24th of November 2017. And it is a meeting that we touched on briefly in the evidence of Mr. De Freitas yesterday, but you were also present at this meeting, is that correct?
Yes, I was.
And at this meeting, there was an engagement with the so-called interim board of PRASA, a legal animal, the definition of which I have some difficulty in understanding. And you then deal at page 302 and following with what happened in this meeting. You say in paragraph 5.8.118, committee members explained that they had been waiting for answers for over a year, which explained their level of anxiety. And that's in the context of all the various preceding paragraphs in your affidavit. And then you really come to your conclusion in paragraph 5.8.19. Perhaps you should just explain in your own words, what's the point you're trying to convey in this subparagraph?
So I'd just like to place this in context. The fact that MPs had been waiting is something that members of Parliament tend to do, but both in terms of the Constitution and in the rules of Parliament, they have the power to require someone, anyone, to appear before them at any time. So they obviously chose to wait. But the point that I made in 5.8.119 is that the actual content of the investigations being done by Werksman's attorneys were not discussed at all. The only point of discussion, and it was quite clear that it was a decision made beforehand, that this would be the focus of the discussion by the ruling party, was the fact that they had contracted a law firm to do this investigation at some expense, as opposed to getting some organ of state to do it for them instead. And Chairperson, I'd like to raise an issue here. I think it's now common knowledge, but at this point, only people on the inside of what was happening would know that many law enforcement agencies and offices such as the Office of the Chief Procurement Officer, which could do these kinds of investigations, were also purposefully hollowed out and incapacitated as part of the state capture project. And in my view, that's why this is the very strong preference of the majority of members in the committee, is that Werksman's attorney should not do this investigation. And regardless of what they found, that they should not be paid, but that this should rather be handed over to an organ of state.
And apropos of the substance of what Werksman's had discovered and were reporting on, did the majority party MPs show any interest at all in inquiring into what that substance was and pursuing the issues that had been raised by them?
No, that was not my experience. And to this day, even though I was in that meeting and others, I have no idea what the investigation actually entailed.
And I think I was going to take you to paragraph 5.8.121, but really I think you've already made that point. You've already also referred, you did so at an early stage in your evidence, and so I took you to the part of your affidavit that dealt with water and sanitation, the intended inquiry that didn't happen, so we won't repeat ourselves there. But I'd like to take you now to the question of communications and Ms. Faith Mutambi at paragraph 5.9.14. He starts at the bottom of page 309, but immediately moves on to the next page.
I'm there.
Now, there was a meeting on the 27th of March 2018 of the Portfolio Committee on Communications. This is not a committee to which we have previously referred. And this meeting, apparently, so it is said, was requested by your organization. Is that correct?
I'm not sure that we requested it, but we very much wanted it to happen, yes.
And you refer to Annexure 10.1, and Annexure 10.1 is at page 672, and once again we have detailed PMG minutes of this meeting. Now, the minutes show, and you refer in your affidavit to the chairperson of that committee providing an introduction as to what is called Outer's allegation, which was that Ms. Mutambi had sent confidential cabinet decisions and related information to the Gupta family. Is that a fair summary of the sting of what you were alleging and wanted to have investigated and dealt with?
Yes, although I'm not the authority on that, but I think that was the main point.
Are you alluding to the fact that there was another OTA person involved with this particular issue?
Yes.
All right, I understand. And when we look at paragraph 5.9.16, we see that a member of the ruling party, one Mr. M. Kalako, was suggesting that the letter from the Deputy Speaker suggesting this deliberation was vague. So it seems that the Deputy Speaker had asked that there should be oversight by this committee on this issue. But Mr. Kalako said that it was clear that your organization had laid charges against Ms. Mutambi. He said Ms. Mutambi had lied to the ad hoc committee dealing with the SABC, and he did not understand why her issue was being circulated. And he said that the report of the ad hoc committee had made recommendations on actions that had to be taken, it was conclusive in his view. I think, as I recall, that was a recommendation that the president give consideration to maybe relieving her of her duties in that particular portfolio. Is my memory correct in that regard?
Yes.
And then he says he noted that OTA had provided evidence and the decision was simple, that Ms. F. Mutambi should be charged and sent to prison. There was no need for an inquiry to investigate. It would be a waste of parliamentary resources. And then the chairperson says there was a clear report by you on how when I say you, your organization, how Ms. Mutambi had violated the confidentiality of cabinet. It fell under the ethics committee. Now, we dealt with that earlier, didn't we? That is a matter that your organization referred to the ethics committee. Is that correct?
Yes, it is. And we had sent that to them about 6 months earlier.
And your evidence this morning was, to this day, you have had no response to that. Is that correct?
No, we have had no response.
So in short, what came of this request that this committee should investigate and take and exercise proper oversight over and require proper accountability by Ms. Mutambi? What came of it?
Nothing has come of it. And Chairperson, I'd like to highlight this point because this is not only non-action resulting from our allegations, which we don't know whether the ethics committee has dealt with them or not, but it's also the ad hoc committee's recommendations, which I think occurred quite long ago as well. Those recommendations were made by a committee of parliament and nothing happened. On the contrary, Ms. Mutambi was then put in a chairperson's capacity in parliament subsequent to that. So what Dr. Khoza said before, I think is quite relevant here again. And that is that apparently for the kind of transgression that we've seen and that we've noted, that we've alleged, that we've put formal complaints together on, that people are rather rewarded for this kind of behavior as opposed to being punished for it. And I think that really speaks to the discretion that's afforded to members of parliament and political parties more specifically. It's obvious that the ruling party of which she's a part chose not to institute any punishment or any consequences against her. On the contrary, she enjoys a very high public office to this day.
So it's like people can just engage in wrongdoing and not only nothing happens there, not only that there are no consequences, adverse consequences, but they continue or get given higher positions and nothing happens. It's like there is complete impunity.
Yes, Chairperson, that's exactly right. And it goes beyond the recommendations and the submissions we've made as a civil society organization, but the recommendations made by internal parliamentary staff, who I believe really carry the institutional memory of Parliament, these are ignored as well, and those people are disempowered as well. Some of those people have committed suicide, and many of those people have resigned from their positions in Parliament, saying that they are frequently manipulated and abused by senior members of Parliament. So these individuals aren't only free from consequences, but they're also free to abuse the staff of Parliament, people who I believe are really capable and willing to do their work in the public interest, but they're not allowed to do that.
This culture of impunity that you are talking about, is it a result of a situation where, in order for action to be taken, it depends on the majority in the committees, or is it the other factors. In other words, if, for example, the majority party doesn't want its members to be disciplined, then obviously no matter what minority parties say, then there would be nothing that happens. Or are there some mechanisms within Parliament that don't depend on the representation, level of representation of the political parties, which are given the power to make decisions or implement
Chairperson,
decisions?
it's the former. There is no accountability mechanism that I'm aware of that is independent of a majority's consensus. For example, I also indicated this, and I'll probably get to it later on, but in the challenges that I see in the code of conduct, that's really championed by the ethics committee in Parliament, when the registrar makes a finding, and he could have a finding really based on concrete evidence, and he could present that evidence. Firstly, it's confidential, so the public wouldn't know. But then he could present that report to the ethics committee, and they can, according to the same code of conduct, they can simply choose not to do anything with that. They can simply say that, well, Mr. Registrar, we don't like what you're saying, so please stop it, close the report down, and let's move on. And that's what I suspect is happening. And there's no oversight of that. And one of the key recommendations I would like to make, and my organization has consistently tried to make, is that there must be public oversight. And for that to happen, there needs to be transparency. The ethics committee's deliberations are confidential, always. So we have no idea what goes on there. And I think a simple systemic intervention would be to empower both parliamentary staff in Parliament and civil society organizations or representatives of the public to really have some oversight of what Parliament does itself.
Yes. Yes, thank you. Mr. Freund?
Presumably, on the ethics committee issue, what you are contending for is that that should not be in secret. There should be transparency as to the proceedings and the outcomes of proceedings before the ethics committee. Is that correct?
Yes, that's correct. I mean, in the beginning, I tried to appreciate what reasons there might be for that. And one can understand that some investigations require confidentiality and that an investigation could be jeopardized if all its details were known. That's understandable. But after about 4 years of complete non-response from this committee, complete non-action, which they are free to do, I think my perspective has changed, and I think that committee's deliberation should be transparent and open to the public.
I'm concerned about what you say happens or doesn't happen in the ethics committee. But at the same time, I'm keeping an eye on not going beyond what's the terms of reference of the commission. And in order to, I mean, we're looking at the parliamentary oversight on the basis that if the commission finds that the levels of corruption that we have reached and that there was state capture, one would want to say what recommendations should the commission make to try to make sure that state capture doesn't happen again, or to make sure that the levels of corruption are brought down. And that's when one then says, okay, let's look at what structures have a role to play. Then you go to the question of parliamentary oversight. But one must just be careful. So I want to ask you, because you may be able to say, well, you would think that how the Ethics Committee of Parliament deals with complaints against members of Parliament, this is how it would come into the issue of parliamentary oversight, or so that then one can say, okay, it falls within. Because if it falls without, maybe one would just be unhappy, but not be able to do anything about it. Are you able to say anything?
Yes, Chairperson. I understand that there's a limit to this inquiry scope, and various constitutional court judgments have also made the point very clear that it's not the place of any judge to say how Parliament should do its work. And I think that's reflected in the Constitution as well. But what I think someone in your capacity has the position to say is whether or not those mechanisms that are there are being used appropriately, and whether those mechanisms that are there actually give expression and proper manifestation of what the Constitution demands. And in my view, it doesn't. But that's my view, Chairperson.
Okay, thank you. You may continue, Mr. Freund.
Yes, thank you, Chair. Mr. Johnson, is there any reason why you would think that the ethics complaints that you have been referring to that were unresolved have any relationship to the question of the proper oversight by Parliament in respect of alleged state capture or corruption? Is there a connection or not a connection? And if there is a connection, why would you think there is a connection?
I would think there is definitely a connection. The Joint Committee on Ethics and Members' Interests are almost solely responsible for the conduct, ethical conduct of members of Parliament. And if there are instances where either someone external or someone internal is saying that members of Parliament are not carrying out their oversight, and as a result, state capture is left unabated, if that is not followed up, if nothing is done about that, then the ultimate consequence is that state capture continues. And I've noticed that many of the witnesses who come here have said that in their view it is continuing at this moment. And I believe the Ethics Committee's non-action and their confidentiality are very easy masks behind which our leaders can hide. And I think it's a key reason why state capture is continuing. But it's a more general issue. I think the Ethics Committee is really where the buck stops. And they should have brought in consequences, and they still should, for the fact that other members of Parliament and committee chairpersons in particular are not doing their work, or they didn't do their work in the past. And as a result, there was looting in the public sector and taxpayers' money was lost.
Can I take you back to a paragraph that we've already touched on earlier? It's at page 298, and it's paragraph 5.8.104.
I'm sorry, what paragraph?
5.8.104.
Okay, thank you.
Do you have that, Mr. Johnson?
Yes, I do.
The two specific complaints that you have alluded to, lodged by your organization to the Ethics Committee, related on the one hand to the Minister of Communications, Faith Mutambi, and on the other hand, she was the former minister, and also on the other hand, the former Minister of Mineral Resources, Mosebenzi Zwane. What was the nub of the allegation against Faith Mutambi?
I would prefer to give that to the Commission in writing, if that's all right.
Well, we can go to paragraph 5.2, annexure 5.6, if you prefer. Which is at page 606. and it runs through to page 627. It's an affidavit presented by Stephanie Fick of OTA, and it refers to what Mr. Zwane is accused of doing. And in short, it seems to me on a quick reading that it's at the very heart of alleged state capture or corrupt activities. Do you agree?
Yes, I agree.
That's in respect of Mr. Zwane. In respect of...
That was in respect of Miss Mutambi, isn't it? Stephanie Fick, or both? Or both Miss Mutambi and Mr. Zwane?
No, on a quick reading, Chair, of this particular affidavit and this particular annexure,
Yes.
it seems to relate to Mr. Zwane only. But I believe we have referred elsewhere in your evidence today, Mr. Johnston, to...
I've seen one that relates to Miss Mutambi. I'm not sure where it is, but I've seen it and I've read it, and it's very useful. Affidavit by the same deponent, I think,
Yes.
Ms. Fick.
I don't propose, Chair, to belabor the point. The material is before you.
Yes, but I think the point you seek to highlight or to raise with Mr. Johnston is I think the proposition that if the complaint that is referred to, or one, it is that to the extent that the Ethics Committee's jurisdiction is wide enough to include conduct that relates to state capture, if members of the executive or members of parliament are alleged to have been engaged in acts of state capture, corruption, and so on, then then it would be important to look at what the Ethics Committee does when those issues those complaints are referred to it, because if it does nothing, it doesn't deter the members of parliament concerned from continuing, because they know there won't be any consequences.
Indeed, Chair, that is the argument.
Yes.
And you would recall, Chair, that we referred only a few minutes ago to the material at page 310 and following of this bundle, where the Communications Committee thought that OTA had presented such an open and shut case that they shouldn't waste their time with it. It should go to the Ethics Committee. So they certainly had the view, rightly or wrongly, that it was a matter with the Ethics Committee's mandate. Bear in mind, Chair, that these ministers were, at the time of the alleged misconduct, members of Parliament, and are to this day chairs of portfolio committees and members of Parliament.
Well, I've just found the Miss Fick's affidavit that relates to, I think, Ms. Mutambi. It starts at page 682, Mr. Freund.
Yes, thank you, Chair.
It's a very comprehensive affidavit. May I ask Mr. Johnston, is Ms. Fick still without her?
Yes, Chairperson, she is.
Okay, no, because I think that the Commission may wish her to, I may wish her to come and testify based on her affidavit. So that's why I wanted to find out whether she's still there. Her affidavit is very comprehensive. I found it to be quite useful. But that's fine. relevant, somebody in the commission will be in touch with her.
Thank you, Chair.
Mr. Freund?
Thank you, Chair. I just want to go back on to another issue in which you engaged the Chair a few minutes ago when we were talking about the question of impunity. And there was some discussion about to what extent is this the responsibility of Parliament and to what extent might the responsibility lie elsewhere. And I want to refer you to the evidence of several former witnesses. One that comes to mind is Ms. Koza, Dr. Koza. He says, if you look at the rules provide that the chairs of each portfolio committee are determined by a vote of the members of the committee. In other words, the MPs have the power to determine who will become the chair of a committee. But she also said, if I remember correctly, and the record will show whether I'm right or wrong, she also said that in reality, the decision is made by the ANC's deployment committee, that the MPs who come to these committee meetings, portfolio committee meetings, when they are going to elect a chair, come with instructions from the portfolio committee or some other structure of the African National Congress as a party as to who is to be appointed. So that I want to put to you for your comment that the ultimate accountability for the impunity, if it is impunity, of people who have been accused and against whom there is apparently a prima facie case of serious misconduct, when they are put back as chairs of portfolio committees, the accountability must lie with the political party. What is your view on that?
Yes, that's exactly right. And it doesn't come as a surprise at all. As I said before, it's very clear very often that deliberations on record and the formal meetings that someone like myself, who's not part of a political party, are able to attend, that the proceedings are not real. And what I mean by that is that decisions are taken beforehand and then they are acted out as if they were being taken in that meeting. And the selection of a chairperson, I have no doubt that that is exactly the case, that they would be chosen beforehand. And yes, as I said, it's not so much mysterious anymore that I think many members of the ANC, and perhaps they're not the only political party that operates this way, but your alignment must be first and foremostly with the constitution of that political party, not with the constitution of the country. And if those two are in conflict, then you must invariably stick to the constitution and the demands and directives of the political party, not the constitution. So yes, I would say the accountability and the responsibility lies very much with the political party.
Now I want to move on and deal with a new issue, which is the Portfolio Committee on Home Affairs. And I propose to deal with it only very briefly. You will recall that in June of 2017, there was a letter from Mr. Froelich to the chair of that committee requesting an investigation within that committee's remit of the allegations of state capture and corruption. And in particular, it seems, the concern was about the speedy naturalization in unusual circumstances of members of the Gupta family and related persons. Have I summarized that fairly?
Yes.
Now, what you deal with at page 313 and 314 and 315 are two meetings that took place, the first on the 12th of September 2018, which is very much more than a year after June of 2017, and the second on the 12th of March 2019, obviously considerably later. And The net result we find, it seems, at paragraph 5.10.5, and this is only in March of 2019 that this point is reached. You say the inquiry revolved around the allegedly improper relationship between the former Minister of Home Affairs, Malusi Gigaba, and the Gupta family. Their fast-tracked naturalization served to lay a foundation for their intentions to enter into lucrative business relations with the South African government. And then you make the same point as you make over and over again. Mr. Gigaba has not suffered any consequences as a result of the improper waiver of certain requirements, which I think is what the committee ultimately found had taken place. Is that correct?
Yes, that's correct. And I'd just like to qualify that very briefly. His discretion was something that was legally permissible. And I think the main recommendation that came as a result of this inquiry was to actually change that provision in the Act that allows for ministerial discretion on early naturalization. And not only, once again, not only has Mr. Gigaba not faced any consequences, but in my understanding, he's been deployed to Lutuli House as the head of policy. The same with former Minister Mokonyane.
Now, that completes the evidence I propose to lead from you on what we might call issues of fact. But you do also deal at the conclusion of your affidavit in part 6, which starts at page 315, with what you call parliamentary oversight challenges, and you then go on to deal with recommendations. Now, Mr. Johnston, you will appreciate that we are under quite considerable time pressure. So I would like you, if you could, just to speak very briefly to some of your main points. And it seems to me that one of your main points is this: that the rules empower oversight by portfolio committees, but they confer enormous discretion on the committees. And your concern is that whilst they're empowered, the rules, as it were, impose no obligations. And I think the argument you advance is that the breadth of the discretion and the absence of obligation is something that you think needs to be considered. Is that a fair synopsis of your first core point?
Yes, it very much is. And I'd just like to say that one of the core problems that I see in that is that the empowerment of members of parliament and the empowerment of the public is effectively juxtaposed. And obviously that's the opposite of what the Constitution really demands, which is that Parliament is supposed to be the institution through which the public can find its expression in political discourse. And that just isn't the case. I build up to this, but one of my main recommendations is to really better emphasize Section 59(1) of the Constitution, which says that the National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees. And we are very much of the opinion that they do not do that adequately, and that is one of the main reasons why they have been able to operate with such impunity.
If I could just interrupt you there, Mr. Johnston. It seems to me that you're merging two different points. The point you have now been emphasizing is a point that you emphasize in your affidavit. It's a point about the desirability of permitting public participation and civil society organization participation in the processes during which oversight takes place. Is that one of your core views?
Yes, it is.
Okay. But I was actually trying to deal with a slightly different point, which is the first point that you made, and which strikes me as a separate point. If I can take you back to paragraph 6.2 of your affidavit, it's at page 315. There you cite the fundamental constitutional provision of relevance, section 55(2), which says that the National Assembly must provide for mechanisms to ensure, and then you underline the words "to ensure," that all executive organs of state in the national sphere of government are accountable to it, and you underline the word accountable. And I had the impression on a reading of your affidavit that a point you were trying to emphasize, leaving aside civil society participation, is that whether it's the rules or the culture, the fact of the matter is there's enormous discretion as to whether to in fact exercise proper oversight, and that is one of your many complaints. Am I correctly paraphrasing and summarizing one of your points?
Yes, and I also qualify that by referring to the separation of powers, which I think is something that comes to the fore very frequently in the mobilization of the sub judice rule, for example, where the suggestion is that if courts or the public protector or anyone else, any other authority beyond the realm of parliament is dealing with a particular issue, that it either cannot or should not deal with that same issue. And I disagree with that. And even though section 55(2) of the Constitution says that the National Assembly must provide for mechanisms, it doesn't really make it explicit that they must use them. And I think that's the nub of the problem, is that that's precisely the interpretation that members of the ruling party have taken, is that yes, we must provide for those rules, and in my view, those rules are there. There are mechanisms for oversight, but they simply aren't used.
Mr. Johnson, I don't propose to ask you any further questions, save for this. I am well aware that you put a lot of time and effort into drafting this affidavit, and I'm aware that there's a great deal that you deal with in this affidavit that we haven't dealt with explicitly in this hearing. Is there any one or two points that you feel that should have been emphasized and that you've not yet had an opportunity to emphasize?
Thank you, Mr. Freund. Most of the points I wanted to emphasize I have, but the one that I made penultimately on the inclusion of the public and the empowerment of the public and parliamentary staff, I think is one that I should emphasize again. And I also would like to make it clear that both in terms of the finances of Parliament and in terms of the laws that govern Parliament, members of Parliament are the only ones who are effectively empowered. And I think let me be very clear on that. In section 58(1) of the Constitution, it says that cabinet members, deputy ministers, and members of the National Assembly have freedom of speech in the Assembly and its committees subject to its rules and orders, and are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything that they said in, produced before, or submitted to the Assembly or any of its committees, or anything revealed as a result of anything that they have said in, produced before, or submitted to the Assembly or any of its committees. And I would like to just give my view on that. I think that's a provision that's been exploited. And I think that's also a reason why a minister would be called before a committee, before any terms of reference have been put together, simply because one can admit wrongdoing and explicitly one would be protected. And I think that many people who are in Parliament, chairpersons in particular, are people who would rather belong in prison. But there's really nothing for the public to do about that, and I believe that's something that should change.
Thank you, Mr. Johnson. I have no further questions.
Thank you very much, Mr. Johnston, for availing yourself to assist the Commission. We appreciate it very much. You are now excused.
Thank you, Chair.
Mr. Freund?
Chair, the next witness is Mr. Froelich.
Yes.
I note was logged in. I just want to check that he's presently accessible. Yes,
Yes.
he seems to be online. So we
Yes.
can deal with his evidence as soon as you're ready to deal with him.
Yeah, I would like us to take a 10 minutes adjournment and then start with him. Let's just
Yes.
take a 10 minutes adjournment. It's 25 past, but 25 to we should be back. We adjourn.
Good day, Mr. Frolick. Good day, Mr. Frolick. Mr. Frolick, are you there? Mr. Frolick? Hi, Advocate.
Yes, hello.
I'm good. Is Mr. Frolic available?
I believe so. If you can just come on screen.
Mr. Frolic?
Yes, good afternoon, I am.
Yes, can you hear us?
I can hear you.
Thank you.
Can you
We
hear
can
me?
also, yes, we can hear you. Thank you so much, sir. I'm sorry, Mr. Frolic? Mr. Frolic, are you going to take the oath or affirmation?
Affirmation.
Affirmation, thank you, sir. C,
Yes.
thank you, sir. I wanted you to be the last one on the screen.
Yes, all right.
Thank you.
Yes, Mr. Freund.
Thank you, Chair. The next witness will be Mr. Cedric Froelich.
Yes.
Perhaps before I ask Mr. Froelich anything, I should draw your attention to the fact that Mr. Froelich's affidavit forms part of Exhibit ZZ1 from page 1 and following of the Bundle 1. But you will recall, Chair, that there is a set of affidavits from representatives of the African National Congress, of which this was just one. I would propose, subject to your views, that in due course I move to have admitted the entire exhibit, even though not all of the deponents to affidavits will necessarily testify. They have submitted this, and I will be moving, if you so approve, for the entire exhibit to be admitted as a single exhibit.
But the other affidavits are not annexures to his affidavit, are they?
No, they're not.
They are
They are
standalone.
set. If I can take you to page 1 of Bundle 1, Chair.
Bundle, yeah, I'm in bundle 1.
The cover page that I have at page 1 shows that there are actually 9 sub-exhibits, you might call them, each one of which is a self-standing independent affidavit. So, for example, the second one is the affidavit of the late Jackson and Tembu.
Okay, I'm sorry. I think we are
For
not.
example,
I think we are not looking at the same page. But I have in front of me bundle 1. But bundle 1. Oh, okay. No, now I see. Yes, page 1.
take you
Yes.
back to page 1, yes. And you will recall, Chair, and I will deal with this through the witness, but you will recall that the Commission, through the Commission's Secretary, issued invitations to political parties to submit both evidence and representations. And the African National Congress responded to that by, in due course, presenting really as a package the affidavits that we see in ZZ1. They are 9 separate individuals' affidavits, of whom I'm only proposing to call as witnesses 4 or 5, and one of them you've already heard from. But nonetheless, my submission will be in due course, subject to your views, that it should be admitted as an exhibit, regardless of whether the deponents to all the affidavits actually testify orally.
which ones are we going to have the benefit of their oral evidence that you,
Well,
you
Chair,
know as things
we
stand?
have already had the benefit of Ms. Ranto, which was ZZ 1.8. And the content of that affidavit so overlapped with the content of her earlier affidavit that she was not taken in any detail through that, but you have heard her evidence and she has confirmed orally really the content of ZZ 1.8. Mr. Jackson and Tembu would of course have called, but as you're aware, tragically passed away, so we certainly won't have him. The editorial view that that the Commission has taken is that it's not necessary to call Bengu, Exhibit ZZ 1.4, Maluleka, Exhibit ZZ 1.5. As regards Exhibit ZZ 1.1, there is an affidavit there from the Secretary General of the African National Congress, Mr. Magashule. It's uncertain whether he will testify or whether that testimony might be given by somebody else. That we don't yet know. Ms. Letsatsi Duba was scheduled to testify, but was for various reasons unable to do so this week. And Ms. Magadzi is available to testify after Mr. De Freitas.
Yes. Okay, that's fine. Let's go ahead and so the ones you will call are Mr. Frolik. What's the latest on Mr. Smith?
Mr. Frolik, Mr. Smith, I do intend to call. Ms. Letsatsi Duba, if she becomes available. Ms. Magadzi and Mr. Magashule, as things stand at the moment.
Okay, all right. Okay, let me admit them. I guess that we can regard the admission as provisional, and that can be made final in due course once we know who has been able to testify orally and who hasn't. Okay, I think let's proceed on that basis.
Yes, thank you, Chair. Chair, as I say, Mr. Cedric Thomas Frolik is available and I think wishes to take the information.
Mr. Frolik, good afternoon, Mr. Frolik.
Good afternoon, Deputy Chief Justice.
I don't know whether to say welcome back because you have testified before me before, but on that occasion you were here physically, and on this occasion I suspect you are in Cape Town or you may be at home.
I'm at home, Deputy Chief Justice. Thank you.
Yes. Okay, all right. Registrar, please administer the oath of affirmation.
Please state your full names for the record.
Cedric Thomas Frolik.
Do you have any objection to making the prescribed affirmation?
No.
Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Yes, thank you, Mr. Frolik. Mr. Freund, you may proceed.
Thank you, Chair. Mr. Frolik, have you been furnished with a hard copy of your own affidavit, which you submitted to the Commission, with the Commission's pagination numbering evident on the hard copy you've received?
That's correct.
And is it correct that the affidavit that we see from page 47 through to 55 is your affidavit, and that the signature at page 55 is your signature.
That's correct.
And can you confirm the correctness of the facts in your affidavit?
I do confirm.
Chair, in the light of what we've just discussed, I presume this affidavit may be admitted as evidence in its own right, but provisionally together with the rest of Exhibit ZZ1.
Yes, the affidavit of Mr. Cedric Thomas Frolic, which starts at page 47, will be admitted as exhibit. Are we going to say ZZ1 point whatever you
Well,
got that? Or,
Chair, this is strictly speaking ZZ 1.3.
yes. Why don't we stick to that? And we will see at the end if it needs to change for now. Or did you have another proposal?
No, I'm happy that we refer to it as ZZ 1.3.
Yes.
And therefore, if, of course, the whole of ZZ1 is also admitted, it will still form part of that ZZ1 bundle.
Yes. So Mr. Frolic's affidavit will be admitted together with annexures, if it does have annexures. It doesn't look like it does. It will be admitted as exhibit ZZ 1.3. The other affidavits that is now the affidavits of Mr. E.S. Mahashule, Mr. J.M. Tembu, N.R. Bengu, V.G. Smith, H.P. Maluleka, and D.B. Letsatsi Duba are also admitted as provisionally as exhibits, and the exhibits they will be marked as in the case of Mr. Mahashule's one, exhibit ZZ 1.1, in the case of the affidavit of Mr. J.M. Tembu as exhibit ZZ 1.2, in the case of the affidavit of N.R. Bengu as exhibit ZZ 1.4, the affidavit of H.P. Maluleka as exhibit ZZ 1.5, that of V.G. Smith as exhibit WZ 1.6, and the affidavit of D.B. Letsatsi Duba as exhibit ZZ 1.7. You said the one for Mr. Ranto, Mr. Freund, has been taken care of, or is this another one?
Chair, I think strictly speaking, although I intended it to be admitted formally, I'm not certain that I requested you to do that. So the interests of safety and prudence, I would ask that you admit Exhibit ZZ 1.8 as well. The point I make is that when one reads the content of that, it is subsumed into the content not only of her larger affidavit from which she was read, but also into the content of her oral testimony before the Commission. So on that basis, I would ask, for the sake of formality, to admit Ms. Ranto's second affidavit as ZZ 1.8.
Okay, and the affidavit of Ms. D.Z. Ranto as exhibit ZZ 1.8. Her one, I think, would be admitted finally because she has testified. Yeah.
Indeed.
Okay, all right. Thank you.
Thank you. May I proceed, Chair?
Yes, you may proceed.
Thank you. Now, Mr. Frolic, we see from your affidavit that it was deposed to on the 12th of October 2020. Is that correct?
That's correct.
And if we go back to paragraph 5 of your affidavit at page 47 of the bundle, we see that a few weeks before that, you were informed by your organization, the ANC, that this inquiry had invited the ANC to make representations on how it had been carrying out its constitutional oversight obligations over the executive and holding it accountable for the performance of its functions and the exercise of its powers. Is that correct?
That's correct.
And in fact, I'm not sure if you're aware of this, but there were several letters addressed to the African National Congress at an earlier stage inviting such representations, but due to miscommunication problems, they were not received by the proper persons, or they didn't come to the attention of the persons concerned. And so when it finally did come to the attention of the African National Congress, you were one of several people, one of 9 to be exact, who were asked by the African National Congress to depose to affidavits, as it were, in response to the request from the Commission to the African National Congress. Is that correct?
That's correct.
Yeah, I might just make clear for the record.
I think, Mr. Freund, it's appropriate for me to say that we appreciate that the African National Congress responded to that invitation, because many political parties represented in Parliament did not respond. But as I understand, the African National Congress, the DA as well, or technically not, the DA.
Chair, if I may say so, the DA were instructed Ms. Matsoni to represent them, and the comments that she made in her affidavit were made on behalf of the DA.
Yes, so the DA also responded positively to that invitation. So I'm not aware of any other political party represented in Parliament which were invited, because I mean, I know that the IFP was invited, the EFF was invited, quite a number of them, I think, were invited, but it seems only the ANC and the DA responded positively. I don't think we received any responses from the other political parties. Is that your understanding as well?
Chair, to the best of my recollection, the Commission did receive certain responses by correspondence indicating that other parties would probably be interested in making submissions or evidence. But to the best of my knowledge, that was never subsequently furnished.
Yes. Okay, all right. Maybe if there are any other parties which wrote to the Commission in response to that invitation and said whatever they said, I would like to see that, just so that when I talk about non-reaction or no response, then I'll be accurate, because I thought that all the political parties would embrace this opportunity of assisting the Commission to understand what the challenges are with oversight, performance of oversight functions, the mechanisms that Parliament has, whether those mechanisms for oversight are adequate, or what challenges are there, how should they be addressed. I thought that, and what experiences they have had of oversight, performance of oversight functions, but a number of them did not. So I would like to just know who who responded and said what. But otherwise, that's fine. We can proceed.
Thank you, Chair. We will endeavour to put that before you in a pack that contains the relevant correspondence.
Yeah, okay, all right.
Now, Mr. Frolick, you say in your affidavit, and this has been referred to by several witnesses before, you have testified, that you are the House Chairperson, Committees, Oversight and ICT in the National Assembly, and that you have occupied that role from 18 November 2010 until the present. Is that correct?
That's correct.
And precisely because you have occupied that role, you were requested by your party to depose to the affidavit, pursuant to which you are now appearing before the Commission. Is that correct?
That's correct, Advocate.
And you say in your affidavit that you wish to explain how the House Chairperson functions in Parliament. I'm looking at paragraph 7 of your affidavit. And perhaps with reference to what you say in paragraphs 8, 9, and 10, you might like to explain the function of the House Chairperson. Am I correct? Colloquially in the political world, the office has come to be referred to as the Chair of Chairs.
That's correct, Advocate.
I'm going to use that colloquial term, the Chair of Chairs. And if you could just explain what the functions are, but perhaps it might assist you if we have regard to the rules to which you make reference. Am I correct that you were furnished with a copy under the heading of a file under the heading Legal Framework Bundle? That you were furnished with the National Assembly Rules 8th edition and National Assembly Rules 9th edition.
That's correct.
Those two sets of rules comprise the sole content of the legal framework file. And in your affidavit, Mr. Frolick, in paragraph 9, you refer to Rule 262. Now, I ask you to turn to page 322 in this legal file, the top red pagination sequence. If you go to page 322, you will find, I think, a Rule 262. Is that the rule to which you were referring in paragraph 9 of your affidavit?
That's correct.
And if we go back to page 170, keep your finger there, but just go back to page 170 in the same legal file. You will see that that's the cover page of the Rules of the National Assembly 9th edition. Is that correct?
That's correct, sir.
If you go to page 172, you will see that that 9th edition was adopted by the National Assembly on the 26th of May 2016. Is that also correct?
That's correct, sir.
So when you refer to a rule in this affidavit, you are understandably referring to the rules as they currently stand, which are the rules that were introduced with effect from the 26th of May 2016. Do I understand that correctly?
Correct.
But we must, of course, bear in mind that through some of the events of relevance to the Commission and the evidence on parliamentary oversight, the previous edition, the 8th edition of the rules, was in force. Do you agree with that?
I agree.
Nonetheless, so far as I'm aware, and unless you point it out as we go along, my impression is that insofar as it pertains to the House Chairperson, the rules as to the responsibilities of the House Chair, there have not been substantial changes between the 8th and the 9th editions. So I'm going to assume, unless you tell us otherwise, that it's reasonable for us to focus only on the rules as they have been since the 26th of May 2016. But if you feel at any point that it's necessary to draw attention to a difference between the rules as they stood at one period or another, then of course you're free to do so.
Thank you.
Now, I took you to, and I'd like you to go back to page 322. That is the rule, as you have already told us, which talks about the scheduling function of the designated House chairperson. That's again another reference to the same office, what we refer to colloquially as the chair of chairs. Do we agree?
I agree.
And what it says is that the House chairperson designated by the Speaker, and that was in the period you've indicated yourself, must, as delegated by the Speaker, implement any policy, directive or guideline on the scheduling and coordination of meetings of all committees and subcommittees. Is that correct?
That's correct.
Now, if you would go back to page 309 in the same bundle. We see that that is the portion of the rules from Rule 225 onwards, which deals with portfolio committees. And I might mention as distinct from certain other committees that are dealt with elsewhere in the rules. Is that correct?
That's correct, sir.
And then at if we go back to part 9 on the preceding page at 309, page 309 in the legal file, we find there's a reference to the Forum of Committee Chairpersons, which is established by Rule 221. Is that correct?
That's correct.
And it provides in Rule 222 the Forum of Committee Chairpersons consists of A, the House Chairpersons. So who would those be?
The House chairpersons include my two colleagues. There's a House chairperson responsible for internal arrangements, and there is also a House chairperson responsible for international relations.
Thank you. So it consists of those two colleagues of yours. And then in sub B, this forum also consists of the chairperson of each assembly committee and each assembly member who is a chairperson or co-chairperson of a joint committee or an assembly member of the committee designated by the chairperson. If you could just explain that to those of us who are not familiar with parliamentary officers and officials.
Let me approach it first from the perspective of the National Assembly. It will include all the chairpersons of any parliamentary committee. We also have, include then the other House chairpersons as per invite. And then it also includes any ad hoc committee that may be formed for that chairperson to become part of that committee. It also includes the other committees apart from portfolio committees, such as the standing committees. And at times, depending on the agenda, we have developed the practice that the chairpersons, including each House chairperson of the Council of Provinces, also at times follow part of these committees, depending on the agenda items to be pursued.
Now, if we look at Rule 223, that focuses on the chairperson of that committee, and that is you. Is that correct?
That's correct.
And that provides in subsection 1 of the rule, the House chairperson designated by the Speaker presides at meetings of the forum of committee chairpersons, and then provision made for another House chairperson to preside in your absence. Is that correct?
That's correct.
Now, above and beyond the rules to which I have now referred the chair of this commission, could you perhaps just explain in a little more detail, as it were, the practical reality of what the post of chair of chairs comprises?
No, thank you. The chairperson or house chairperson of committees is a position that is delegated responsibilities by the speaker. And the speaker, as you've correctly referred to earlier, is directing the house chairperson then to implement any policy, directive, guideline on the scheduling or coordination of meetings and also committees and subcommittees. In practice, what it means is that I work with the chairpersons on a daily basis to oversee the implementation of the program of Parliament as far as the scheduling of committees are concerned. The program of Parliament is determined by the National Assembly Programming Committee, and then also the broader framework coming from the Joint Programming Committee. In practice, what it would mean is that when there's any scheduling issue, and I want to clarify scheduling, if a committee have planned and submitted a program to my office, then that program must be implemented. And the reason why it is implemented is, or must be implemented as submitted, is because it gets published to the public in order to allow for anyone who wish to follow a committee meeting to know that such a committee will be sitting and the items that they may consider. They also then submit applications, that is the chairpersons to my office, for activities.
Can I just interrupt you and say, when you refer to chairpersons, if you would indicate chairpersons of what? Because
Chairpersons of committees. I refer to the chairpersons of the portfolio and select committees in the National Assembly specifically.
Right, thank you.
So they will submit their programs and other activities that they want to undertake. On an annual basis, it's also the responsibility of the House Chairperson committees in the National Assembly, as well as in the National Council of Provinces, to see to it that the budget is subdivided to the different committees and that the necessary resources are made available to the committees to implement their programs. This budget is an allocation that the committee section receive. It does not reside in my office. It's a political budget that I preside over, but the actual budget resides in the committee section of Parliament. So the committee section of Parliament will require directives from myself and my colleague in the National Council of Provinces as to how that budget must be allocated. If there are any specific issue where chairpersons require guidance on related to their committee work, they will approach my office for assistance. Or if they are busy with public hearings and there are certain issues that may arise, they will also make contact with the office that I currently hold. That is, broadly speaking, the role and responsibility of the office, and all these activities get reported back to the Speaker of the National Assembly, who have designated this function to me.
Right. Now, I wanted to focus on precisely that next. To understand clearly the proper role of the Speaker and the proper role of the Chair of Chairs in relation to the issues of interest to this part of the Commission's investigation, which is all about portfolio committees and oversight. What's the role of the Speaker? What's the role of the Chair of Chairs, if any?
1 second, Mr. Freund and Mr. Frolik. Thank you. You may proceed. You may proceed.
Mr. Frolick, do you recall the question? Did you hear the question?
Can you just repeat the question again, please?
I'm particularly interested in the issue of oversight by Parliament over the executive. And I'm interested in that question in the context of the work of this commission, which is in relation to allegations of state capture and alleged corruption. And what I'm asking you is to explain to us the roles, on the one hand, of the Speaker, and on the other hand, of the Chair of Chairs, when it comes to what practically is to be done about oversight functions. So let's start with the Speaker, and then, because you talk about your function is to implement delegated functions. So I'm trying to understand what the Speaker is responsible for and what your office is responsible for.
The Speaker is primarily responsible to see that whatever decision is taken in terms of specific oversight activities and the work of committees is executed and implemented by my office. What that in practice will mean is, if the Speaker through any forum become aware of any specific issue that needs to be pursued by a committee or oversight that must be conducted by a committee, she can bring it to my attention, and there'll usually be a discussion, and I will contact the relevant and write to the relevant committees to transmit the instruction by the Speaker in terms of what needs to be done.
All right. Well, let's deal with that in a little more detail, because it seemed to me you started with the later before you dealt with the earlier. The later is ensuring that resolutions of oversight activities are in fact implemented. But the earlier must be the process of actually conducting that oversight and making recommendations. Now, did I hear you correctly a moment ago that the Speaker can, and presumably sometimes does, issue instructions which you then pass on to chairs of portfolio committees that they should implement certain oversight activities?
That's correct, sir.
And do you also perform such a function? Do you also apply your own judgment from time to time as to what types of oversight functions seem to be necessary? And when you think such a function is necessary, do you pass that on as a request or an instruction to chairs of the relevant portfolio committees?
If there are any specific matter that is discussed in the different forums of Parliament, which may be the Chief Whip's Forum, the Committee of Chairpersons, it could be a discussion that has been taking place in the National Assembly Programming Committee, or any specific matter that has been brought to my attention, I will usually discuss it with the Speaker, but also very importantly with the Chief Whip of the majority party. That is also has responsibilities in terms of the implementation of the program and seeing to it that there is a coordinated way in which we are working in Parliament.
And would that include discussions where relevant with the chairs of particular portfolio committees?
That's correct.
Now, the structures that you've just been referring to, if I understand correctly, are really all official structures of Parliament as an entity, the Chief Whip's Forum and the others that you mentioned. Am I correct?
That's correct.
But there is another structure of which I have been told. I think it's known as the Political Committee. Is that correct? Is that the correct name? And if so, could you explain what it is? This seems to me to be an ANC structure.
That's correct. The Political Committee is an internal ANC structure consisting of members of Parliament and members of the executive who has been deployed by the ANC to serve on that structure. That structure is usually chaired and convened by the Deputy President. It includes the Speaker, the Deputy Speaker, the Chairperson of the National Council of Provinces, as well as the Deputy Chairperson of the National Council of Provinces, the Chief Whip of the ANC, the Deputy Chief Whip of the ANC, the Chief Whip of the ANC in the National Council of Provinces, and a few other members as identified by the National Working Committee in the NEC to form part of that structure.
Now, before we deal with the function of that committee, I just want to understand a little bit more clearly the composition of that committee. And you said members of parliament and certain members of the executive. Now, if we focus on those who are members of the executive, are those also required to be simultaneously members of parliament in order to be participants in this ANC political committee?
That's correct, sir.
So it comprises, in addition to the Deputy President of the country, who serves as chair of this committee and who is the leader of government business, it comprises really some of the very most senior MPs, some of whom are ministers and some of whom are not ministers. Would that be a fair summary?
That's correct, sir.
Now, what is the function of the political committee of the ANC that you've just described?
The function of the political committee primarily is to give guidance and to oversee the work of the deployees of the African National Congress in the National Assembly and also in Parliament, my apologies, but also to deal with any situation that may occur that may require further political guidance. That is primarily the role that the political committee play. And it is also a forum where colleagues exchange their different experiences to see to it how the institution can function at its optimum.
All right. Now, going back to your affidavit, in paragraph 12, you say that the practice has developed over the years that the chair of chairs has responsibility to provide procedural advice and guidance to the chairpersons of portfolio committees. That's correct, is it?
That's correct.
And what you then go on to deal with in your affidavit is the fact that prior to the 2009 general elections, the National Assembly and the National Council of Provinces adopted what you refer to as the Oversight and Accountability model. That is factually correct, is it?
That's correct.
Now, once again, I would like to refer you to a document that I believe was and should have been sent to you. In the reference bundle, at page 1 and following, we find a document that is labeled Oversight and Accountability Model. Is that what you have in mind when is that what you were referring to in paragraph 13 of your affidavit?
That's correct, sir.
1 second, Mr. Freund. Yes, thank you. I've got it. You may proceed.
And would it be fair to say that prior to the adoption of this particular model by the National Assembly and by the National Council of Provinces, there had been a period of reflection and debate and investigation as to how Parliament should execute what the Constitution requires of it, namely to maintain oversight over the executive and to hold the executive accountable, And this was the product of that reflection, and this was ultimately the decision of the National Assembly and of the NCOP as to how these things should be done.
That's correct.
And you say in your affidavit, at the foot of page 48, the model serves as a policy guide to Parliament on the procedures to follow in order to conduct oversight over the executive and to hold it accountable for its actions. And then you say, the oversight and accountability model of Parliament is premised on the sector oversight model, you referred to it with the acronym SOM, and ushered in a strong intent to grow Parliament's capabilities to advance and continuously strengthen its oversight and accountability mandate, and thereby realize the aspirations of improving the lives of South African citizens. I presume you stand by that.
That's correct.
Now, I'd like to refer you to some evidence given by the very first witness, Mr. Gordy. When I say first witness, the first witness in this stream of evidence. And just bear with me for a moment, please. Well, perhaps before I do that, can I take you in the reference bundle to pages 30 to 31.
Yes.
Part 4.1.4 of this model, which has become known colloquially as the OVAC model. Am I correct?
That's correct.
And you say this was adopted in 2009, if I recall correctly. Is that right?
That's correct.
And it starts at the top of page 30 in the reference bundle under the heading Oversight Advisory section as follows. In developing the oversight model, the need was identified for support services relating to the monitoring and tracking of issues between Parliament and the Executive, and on all other related matters within Parliament's broader mandate. An oversight and advisory section ought to be created in response to the need identified. Its main functions will be to provide advice, technical support, coordination, and tracking and monitoring mechanisms, and I particularly emphasize on tracking and monitoring mechanisms, on issues arising from oversight and accountability activities of members of Parliament and the committees to which they belong. And then if we go down a little bit in the same page, it says the foreseen objectives of the Oversight Advisory section encompass the following. And the second bullet point is tracking and monitoring executive compliance in respect of issues that individual MPs raised flowing from constituency work. Next bullet point, assisting with tracking, monitoring, and following up issues raised through the parliamentary democracy officers, and so forth. And then the third last bullet point in that section, assisting with monitoring and tracking executive compliance with House resolutions. I want to emphasize that one. Assisting with monitoring and tracking executive compliance with House resolutions. And then it talks further about the subdivisions of this envisaged oversight and advisory section. And you will see if you turn to the next page at page 31, that there is to be, according to this document, a tracking and monitoring unit which will address decisions in the houses at committee level, as well as issues emanating from the floor of the houses and from committee reports that get tabled in the House. And then the real nub of it at the end of that portion, before the section on the Reserve Bank, it is therefore recommended that Parliament must speedily establish this section with full resources, capacity, and personnel for the efficient fulfillment of the objectives of oversight and accountability. That was a formally adopted decision of the National Assembly that this should be done. Am I right?
That's correct.
Was it done?
What happened was that the implementation thereof, for its full implementation, was costed by the administration. And at a certain point, they indicated that it will have to be a phased-in implementation to realize the full objective that has been set. Subsequently, that function resorts under the National Assembly Secretariat, the Secretary to the National Assembly, who together with the committee section is responsible for that. So that was not fully implemented due to the budgetary constraint that was identified at the time. However, I indicated in numerous forums that that situation is untenable for the simple reason that if you do not have enough warm bodies to focus on a daily basis on this important function, then you're going to have different or mixed outcomes. It was then decided to task the ICT section of Parliament to start developing, and that is from about 2 years ago, start developing and looking into putting in place a system to electronically track all the decisions that is taken by the National Assembly, and I must also add the National Council of Provinces, after committees have submitted their reports, to ensure that we do get timeous feedback from the executive. In practice, what has happened is that after such decisions have been transmitted via the office of the Speaker to the executive, they will respond. One, to acknowledge receipt of the report, and then secondly, in certain instances, there is a response as well that goes through to the relevant committee. However, this is a mixed situation because you will find that certain departments in the executive are very prompt in terms of their response, while others do not respond to these reports and the recommendations that has been adopted by the House. That is where we currently are as far as that specific function is concerned. We've made proposals that the budget that has been allocated to Parliament must be reworked, and the current Speaker is paying attention to that, so that this critical oversight function, and I want to add here, Advocate, my speeches in the National Assembly when we discuss Parliament's budget vote year after year reflect on this in terms of the resources that are allocated for oversight. If you take into account that the National Assembly alone has plus minus 40 different portfolio and select committees, together with the National Council of Provinces, the amount that is made available for oversight in its entirety is very, very little compared to what the expectations are. So we must continuously then ask for violence to be done, for money to be moved around. And I can confidently say that I believe that the budget allocation that are given to committees are not sufficient for them to implement and execute all their tasks that they are supposed to do.
Now, we've heard evidence that Parliament's budget exceeds 2 billion rand. Is that correct?
If my recollection is correct, that is more or less the amount.
What amount, when you say the amount available for oversight over entities is very little, what is that amount?
That amount, Advocate, over the years, there's been incremental adjustments, but it stands in the region between, and this is out of a budget of 2 billion rand, it stands between 50 to 60 million rand.
So somebody in Parliament or somebody speaking for Parliament has made a choice to allocate a mere 50 to 60 million rand to the oversight function out of the 2 billion rand odd available to it. Is that correct?
That's correct.
Who makes that choice?
Well, there is a budget committee. There's a budget committee that works closely with the executive authority, and it also includes the secretary to Parliament, and they engage with the chief financial officer, with National Treasury on a regular basis, and then based on what is received by Parliament, it is subdivided into the different programs that are there.
And that 50 to 60 million rand is intended to cover what? Is that intended to cover all the financial requirements of all the portfolio committees?
That is correct. And if I may elaborate, let me just give you a bird's eye view of how that money is then spent. That money is allocated to the budgets of the different portfolio committees and the select committees to do the following. That is to plan and also to implement and host their regular meetings that they will have. The second part thereof is when they want to advertise an advertisement to invite public comment on a piece of legislation. Now, at any given time, you will find that there are about between 30 to 40 bills in Parliament, and part of the oversight and accountability model also has a section that clearly sets out what public participation must be. So advertisements is one element of that. Another element could be radio station advertisements. And any advert going out to newspapers these days costs at least R250,000 per advert for public comment. Add to that also the oversight visits that are undertaken by the different portfolio and select committees. This includes the traveling of staff, the members of Parliament, their accommodation, as well as any other incidentals such as hall hire, such as the provision of basic refreshments such as water to participants. And if you take into account the necessary measures that are in place for transport of members of Parliament, it will include the airfare, if they are traveling by air, their ground transport, as well as transport to get them back home again. So the amount that is there is really to do most of those things. Now you come to a situation where we found ourselves in 2017, where a need was identified for Parliament to do specific work in terms of those 4 committees of the National Assembly. To implement that, you must then go back into the budget forum and ask the powers that decide, say to the Secretary of Parliament, let us find more money to fund some of these activities. And that is usually done in the form of environment from other programs that has either not been implemented or there is a delay in the full implementation of those programs. And this is not sustainable to exercise oversight.
Well, those are your words, not mine. But you've also said that you repeatedly raised the inadequacy of this budget if one was serious in requiring or wishing to capacitate the very numerous portfolio committees to exercise their oversight functions. I take it that it's implicit in what you've said that you did not get a sympathetic response or that it didn't change materially.
If there were any changes, it was, as I say, it was simple environments as the need may arise. And I must add that the chairpersons, when they plan for these oversights, they go to their strategic planning sessions and they come up with what they want to do. And you cost those programs, then it usually exceeds by far the money that's available. And then usually my last point of call would go to the speaker. And the speaker would say, okay, I'll take it up. And there would be a environment that needs to be done. But that is not the way it is supposed to fund the oversight function. Oversight and committees should be one of those key priorities of how the budget of Parliament is divided and allocated.
Well, I agree with you. Those are your words and not mine. But can I put to you for your comment what seems to be the obvious corollary to what you've said? That Parliament has simply not been serious about exercising oversight over the executive. If it was serious, it would have reapportioned the allocation of resources. What's your view on that?
My view is that the committees and the numerous reports that are there that has been tabled by committees have done a lot of work in terms of exercising oversight over the executive. Under these difficult constraints, they have exercised their oversight. It is a matter of opinion whether that oversight work that has been done was sufficient or not. But I cannot fault the majority of these committees for going beyond sometimes what was possible to do their oversight function and execute their mandates.
Well, if it's a matter of opinion, what's your opinion? Is
So
it your
my opinion is, if I may,
all right, carry on.
my opinion is that with the limited resources that has been made available, the committees in Parliament, and remember, committee work is one element only of oversight. There's other forms of oversight that also happens in Parliament, in the National Assembly, and in the National Council of Provinces. If under these difficult conditions, they have gone very far to exercise their oversight in terms of what the rules and the Constitution is demanding from them.
All right, well, let's go back a step. I took you at pages 30 to 31 of the OVAC model to the tracking and monitoring unit that needed to be resourced and needed to be effective if oversight was to be effective. Do you recall that?
That's correct.
I now want to take you to the evidence of Mr. Gordy. Mr. Gordy said in an affidavit that a matter of intense frustration to him and to his committee scoper was the absence of tracking and monitoring of the multiple recommendations that that committee made for what you might call remedial action, things to be done and to be reported back on. And he says there was simply no system in place that achieved that. Now, do you agree with him that his frustration and concern was absolutely legitimate?
I can recall that I've had a discussion with the Honourable Gordy specific around monitoring and tracking and the full implementation and realization of that. That capacity was created in the office of the Secretary to the National Assembly for our purposes now, and also in the committee section. However, that monitoring and tracking system had its flaws because it was not fully implemented as envisaged in the oversight and accountability model.
Well, aren't you being a little bit euphemistic? Wasn't it frankly an abysmal failure? Wasn't it frankly completely unable to, or perhaps unwilling to, monitor and check the adequacy of the executive responses to the recommendations of portfolio committees which had been adopted by the House and therefore became House resolutions?
Well, from the position where I sit and the work that goes through the National Assembly, I know there's very dedicated people working at that National Assembly table and also in the committee section, who are dedicated to their work and who have never ever received any instruction as what has been sent through and to keep track of that. I do think that the full implementation of that monitoring and tracking mechanism, by properly resourcing it and creating, my view was, even though the model doesn't say that, was to create a dedicated unit of people who know how the National Assembly Secretariat works, together with the committee section, to be seized with that on a daily basis. Instead, you would have found now that some of the human resources at the National Assembly table together with the committee section, also became seized with that matter, coupled with the other work that they were doing. And that made it extremely difficult for them to be effective and to give you timeless responses in terms of what is being responded to.
Well,
Let me
Mr.
read-
Frolik, I'm sorry, Mr. Freund. Mr. Frolik, why was that allowed to happen? You are one of the senior people in Parliament, number one. You have access to the Speaker. You have access to the leaders of the majority party. Why was that allowed to happen?
Deputy Chief Justice, I've indicated earlier my frustration that I've shared, not only with my colleague who's also a House Chairperson in the Council of Provinces, because the same would apply there, and to share it with the Speaker when it comes to the implementation of these things. Also, with the Chief Whip of the Majority Party and the late Minister Jackson Tembu is also on record in terms of the poor resourcing. So the decision makers who sit there and divide that budget of Parliament is where the problem is. For one reason or another, this was the allocation that was given, and the monitoring and tracking function was never implemented to the extent in which it was envisaged.
Now, I still want to put to you what Mr. Gordy says.
I'm sorry, Mr. Freund, I want to make sure I understand what Mr. Frolik is saying. Are you saying a certain structure, maybe it's a committee within Parliament, has the task or had the task of allocating a budget for these activities of Parliament, but they simply did not allocate enough? Is that what you are saying?
Yes, Deputy Chief Justice, and if I may add, what will happen is that once Parliament and the structure develops the budget proposals for Parliament, it gets submitted to the National Treasury. And every year you will hear that Treasury has said they cannot give the amount that has been requested, and we need to cut back on the different programs that are there based on the amount that the Treasury is giving to the National Assembly. And as a result, you'll find that there are certain key programs, such as this that we are talking about now, who always are at the shortest end of what is allocated ultimately in Parliament and its structures.
So as you see it, the source of the problem is lack of adequate funding for these activities.
That is one of the key reasons, Deputy Chief Justice, because for committees to do this oversight work, they also need staff, they need the personnel. And if you have a budget shortfall, it doesn't only impact on the budget that the committee has, but also on the support staff that can be appointed to assist them in these critical functions. That is one of the primary reasons why you sit with a situation where I can make a statement confidently to say that the oversight function of Parliament is not properly funded.
Well, my own impression, and I haven't reflected on this extensively, but my own impression is that the oversight role or function of Parliament must be the second most important function of Parliament, coming after the function of making laws. And if that is so, one would have expected that Parliament and the majority party would be concerned if such an important function of Parliament was severely underfunded. Is my understanding of the oversight function being maybe the second most important, close to your own understanding in terms of the functions of Parliament?
I concur with you, Deputy Chief Justice. Oversight includes different types and categories of oversight.
Yes.
And one of them
yes.
is financial oversight.
Yes.
So if you are constrained in terms of this, and let me go further to use an example, that when the budget is presented by the Minister of Finance, and it runs now into trillions of rand, you need to oversee the expenditure, not necessarily only at the national legislature, but you need to oversee the expenditure that takes place nationally, provincially, and locally. And I'm of the firm belief that you will empower that oversight function to ensure that the intended objectives of the Minister of Finance and the government is achieved. If you do not do that, you run the risk that certain things may slip through, or that you do not have the requisite capacity and tools to effectively monitor those budgets that are there. And that is why we rely heavily, for instance, on the Office of the Auditor General to assist portfolio committees also in that regard, because we have a common approach that financials oversight is of critical importance if we wish to implement the programs and improve the lives of the people.
Mr. Freund, just continue. I think what you are going to be going into in terms of Mr. Godi's evidence will touch on some of these issues, and I might have other questions connected with these issues later on. But I think just continue.
Thank you, Chair. But if I may, with your leave, I just wish to address some of the evidence just given. Mr. Frolik, I understand that Parliament may wish to receive from Treasury's proposed budget a bigger overall budget than it received. That seems to be the iron law of political life. Everybody wants more from the Treasury. But your own evidence, as I understand it, is that of the order of 2 billion, in other words, 2,000 million, is allocated to Parliament. Are you still there? Oh, you can see me. Yes, you're there.
I can hear you.
And how many portfolio committees, select committees, and comparable committees are there in the National Assembly and the NCOP?
At any stage, there's not less than 50.
Not less than 50. And what you've told us is that of that 2,000 million rand, 50 to 60 million rand is allocated to the oversight function. Have I understood that correctly?
That's correct.
So approximately 1 million rand per committee per annum. Is that correct?
That's correct.
Now, that allocation decision is a decision entirely within the control of Parliament as to whether they're going to prioritize oversight and allocate more than 50 million to the oversight function. Would you agree with that?
That's correct.
So it's not Treasury, but Parliament that has decided to so substantially downplay the resourcing of the portfolio committees, which serve as what many people call the engine room of oversight. Would you agree?
Correct.
Now, that is the context in which Mr. Godi, the first witness in this stream, gave evidence. And he gave evidence that, according to him, it was acutely aware, Scopa was acutely aware of very substantial and deteriorating irregular expenditure as well as wasteful expenditure and the other categories dealt with in the PFMA. You still there, Mr. Frolik?
Yes, we are experiencing probably load shedding somewhere, so at times my video gets blurred.
All right. If you don't hear me, please tell me.
I can hear you. I'll alert you if I can't hear you.
Thank you. So Mr. Gori's evidence is objectively and in accordance to the information furnished routinely and correctly by the Auditor General's Office, there is not a minor problem of irregular expenditure. There is a huge problem of irregular expenditure getting progressively worse. And he says, Scopa routinely issue reports which not only note the nature of the problems, but make proposals for their corrections. And he says, but our proposals are very largely ignored. We receive no substantive feedback. Now, do you have any reason to dispute factually that evidence by Mr. Gori?
No, Mr. Gori is correct, sir. As I've indicated, that with the limited resource and in terms of human resource of following the executive action that needs to be done and the mixed response that you receive, Mr. Gori came to the correct conclusion.
Right. Now, Mr. Gori says that when he experienced that problem, and he chaired Scopa both in the 4th and 5th Parliaments, he said the following, I'm quoting from page 116 in Bundle 1, paragraph 6.31 of his affidavit. I don't think you would have this, Mr. Froelich. He says this, but there was no structured mechanism in place to follow up adequately and ultimately to hold the executive accountable. In my view and the view of the committee, this severely hamstrung the exercise of adequate oversight. Committee members became increasingly frustrated with the lack of responsiveness of the executive. In an effort to remedy this, I approached the Chair of Chairs, Mr. Cedric Froelich, sometime during the 4th Parliament. He gave me an assurance that the Office of the Speaker would configure a dashboard which would keep track of deadlines and follow up and ensure compliance with all House resolutions, but no such dashboard was configured and no alternative mechanism was adopted by Parliament to monitor and enforce compliance with House resolutions. Are you saying he's mistaken? Are you saying there was a compliance mechanism?
No, we had a discussion. Mr. Gori and myself had a discussion around the matter of the monitoring and tracking and how it can be approved. However, that dashboard that he's talking about, as well as everything that goes with it, was not implemented. It is only 2 years ago that, and well before COVID, we were supposed to receive a report on it from the ICT section, at the click of a button to see what was happening. Instead, in its place, due to the budgetary constraint that was there, that monitoring and tracking mechanism was then put in place, not in a dashboard form, but at the National Assembly table, supported by a certain section in the committee section.
Well, it's there that I'm taking issue with you, or at least seeking further clarification from you. Because I get the impression that the impression you are trying to convey is that it was not perfect, but it was functional. It was reasonably functional. And that there was a procedure which monitored and responded when there was inadequate executive response to the requirements of House resolutions. And I want to put to you that can't possibly be correct, just on what you've already told us. So I want to give you a final opportunity to tell us to what extent you agree that the mechanism that was in place was in fact inadequate to monitor compliance and to report on non-compliance and to prompt the necessary action to secure compliance.
The mechanism that was put in place was to put a system in place, not as a replacement for the monitoring and tracking mechanism as envisaged. There were flaws in that system that are put in place because it takes time and there's a lot of paperwork going to and fro, and it could possibly not achieve the original objective that was set?
Well, let's just consider this conceptually and systemically. The purpose of portfolio committee oversight and then reports on such oversight to the House is to identify malpractice and other problems and to propose what should be done to remedy that. And that is, as a matter of practice, when the committees are functional, contained in reports that they submit to the House for adoption. Am I correct?
That's correct.
And as a matter of routine formality, the House is in the habit of adopting those committee reports. Is that correct?
That's correct.
And what you say, and I don't think that Mr. Gordy, for one, would dispute this, is that the next step is for the Speaker to take responsibility to ensure that those resolutions of the House are communicated to the relevant representatives of the Executive. Is that correct?
That's correct.
Now, those reports, those resolutions of the House, frequently require certain steps to be taken by certain persons by certain times. Is that correct?
That's correct.
And therefore, if one is going to exercise oversight effectively, it is essential that somebody is responsible for ensuring that they know by when what responses are required from who. Would you agree with me?
Correct.
And to be effective, that system would need to have a mechanism to detect when there has been a failure to report back adequately and substantively by the specified time. Do you agree with that?
Correct.
Now, you say that there are some departments that do not only acknowledge receipt of the reports, they also respond substantively, and I suppose some of them must respond appropriately and substantively, and they must do what's required, in some cases at least. Would that be correct?
That's correct.
But I take it you would agree that it is not at all uncommon for the representatives of the Executive who are required to take remedial action by a certain time, firstly, not to do so, and secondly, not to report back that they have done so as is required by House resolutions.
That's correct.
And will you agree with me that despite the fact that that is true, there has not been in place an effective mechanism to address that problem and to ensure that where remedial measures were required by House resolutions, the required remedial measures were in fact taken by the representatives of the Executive?
That's correct.
Let's then move on. Chair, I don't know whether that is a time at which you would want to raise any further
Yes.
issues. Or whether
Yes, let me just follow up on your last few questions. Mr. Frolick, as I understand from your previous evidence, I didn't check on this affidavit, you have been a member of Parliament from either late 1990s or early 2000s, is that right?
1999, Deputy Chief Justice.
Or at least I was right about late 1990s.
Yes.
Well, that means you have been in Parliament for about 21 years or so.
That's correct.
So, and half of that period, you were occupying the position of Chair of Chairs.
That's correct.
that should give you enough experience of what's happening in Parliament to be able to tell me how long this has been going on, namely there being no proper mechanism put in place by Parliament to follow up and check that the resolutions that have been taken are followed up, and that reports that are supposed to, or responses that are supposed to be sent to Parliament by members of the executive, or DGs and officials and whoever, that they are properly monitored and tracked, and if deadlines are not met, something happens. How long has this situation been going on?
Deputy Chief Justice, when I arrived in Parliament the first time, that problem existed. And that's part of the reason why over the years leading up to 2009, when the Oversight and Accountability model was then formally adopted, was to address the problem that existed for some time. And the problem that you have is that as you change and try to push to work in a new form and going ahead in a new format, it is not so easy to change people's behavior. And for that, you need the requisite support from all the relevant stakeholders who are there. Everyone has a role to play in that, but it is not a new problem.
Of course, you probably can only speak about the time that you have been in Parliament, but if you tell me that when you arrived in 1999, this problem was there, probably the problem has been there from 94.
It's quite possible, Deputy Chief Justice. As I said, when I arrived there, it was there, so it couldn't have only started in 99.
It's unlikely. It's unlikely that there was such a mechanism before 99, and it was stopped. Probably the problem has been there from 94, and that means, is it 26 years? How is it possible that Parliament would not address such a critical part or such a critical problem that would affect the effectiveness of its oversight? How is it possible that I struggle to understand that if Parliament took its function of oversight seriously? How is it possible that a problem like this could go on for so long without being addressed? It happens every year in, year out. One term of 5 years in, one term of 5 years out, and it's not addressed. How is it possible? What is the problem? I'm tempted to say, and I want to say this before you respond so that you can deal with all of this. I'm tempted to ask the question whether it is not the fact that the problem has not been addressed for so long doesn't suggest that Parliament doesn't take the issue of oversight, its constitutional obligation of oversight, seriously enough. What can you share with me?
Well, Deputy Chief Justice, as I said, the 2009 Oversight and Accountability model was part of a number of interventions from the time that I can recall, 99 onwards, on how to address this dilemma and this problem. It's a key function of Parliament. And part of that oversight and accountability model has one, a monitoring and tracking mechanism, but it also gives then the other areas that has been implemented, such as the budget office that has been put in place, a public participation process that has been put in place, the rules, for instance, that has been amended. And we're talking now to the, I think it's the 8th edition of the National Assembly rules that are there to further strengthen oversight. But you deal with warm bodies of members of parliament and also of staff who must work together towards one outcome to address. Also, Parliament, Deputy Chief Justice, is a political environment where there are political dynamics that are playing itself out there. And members of Parliament who belong to the different parties, to the majority party for that instance, each one of them work in this environment where oversight is important and oversight over your direct peers must be done. And at times that is very, very difficult to achieve. And to move towards, my approach was to find a improved and a foolproof method to ensure that you do get the requisite responses by the time you need it, because that will further empower the oversight work by the different committees. But due to the non-implementation of other key stakeholders where the budgets are allocated, this could not be realized.
But would it not be correct to say that if the majority party in Parliament wanted these measures to be implemented and was sufficiently committed to ensuring that these measures are committed, that it would not have been a problem to implement them, because in some cases the minority parties say we can say whatever we say, if it doesn't get approved by the majority, there's nothing we can do, it gets defeated. So I'm asking the question whether there is any reason why these or any other measures aimed at addressing this issue or problem effectively, why they would not have been effected if the majority party was sufficiently committed to solving these problems.
Deputy Chief Justice, I do believe that with the flaws that was previously identified, there has been a commitment to address the situation. However, when we come to this specific point, for me, are crucial in terms of monitoring and tracking the reports and resolutions of the House. That is where we have not achieved what we should have achieved by now. And that would have demanded the support of everyone involved, led by the majority party, of course.
At a practical level, apart from maybe some equipment, maybe what was referred to in Mr. Godi's affidavit as a dashboard, or was it in your affidavit? I think Mr. Godi's affidavit, what the two of you talked about, I'm assuming it would have been some equipment where you could press some button and have a picture of compliance and the levels of compliance and so on and so on. Apart from that, is the position that all that is otherwise needed to achieve this is to employ sufficient staff who are dedicated to this for the 50 or so committees?
Deputy Chief Justice, apart from the hard infrastructure that was required and the staff that are being required, it is also, and it remains the responsibility of each and portfolio committee to also follow up and say, but listen here, we have passed and our report has been adopted on X, Y, and Z. Why has something not happened? And as part of the oversight and accountability model, we introduced a budget review and recommendation report process where committees throughout the year, and it also is part of the previous reports of the committees, where they have an opportunity when they interact with the executive to go back and to say that, but earlier on we have recommended the following. The report was adopted by the House. That requires political leadership at the different at the different committee levels in Parliament. And that is also an area where you would find that there is engagement with the relevant members of the executive. And I'm not saying this because I monitor them every day. It's when we sit, and we sit with the Auditor General, for instance, and the Auditor General gets invited to come and address our meetings at least twice a year to give us the audit outcomes. And then the same chairpersons will say, but there's a regression taking place now in this department that we are overseeing. And in our BRRR report that gets tabled in the House and gets sent to the Minister of Finance, these are the matters that we have identified, but it doesn't improve. So it doesn't only require the infrastructure to be put in place, it requires the political leadership of the chairpersons of those different committees level, committees, to ensure that the recommendations that they have made and also that the report that has been tabled has been driven. But we also need to continuously reassess and assess. And one of the assessments that I did regularly, together with my colleague in the National Council of Provinces, is that a fully functioning monitoring and tracking mechanism will add that capability to the arsenal that the different members of portfolio committees, as well as the National Assembly, have to follow executive action.
Well, you touch on a point which I think is important, namely, without even employing a lot of maybe admin staff, why is it not the function or the duty of the chairperson of each portfolio committee to monitor whether, for example, ministers, in respect of whom his or her committee have made certain recommendations which have been approved by the National Assembly, whether those ministers have complied or not, or if it's DGs or CEOs of SOEs, why can't they do that?
Well, Deputy Chief Justice, that is exactly what the chairpersons, or let me say most of the chairpersons over the years that I worked with, have continuously raised. But it seems as if there is this view in terms of the separation of powers between the judiciary, the executive, and the legislature, that the legislature has a more junior role to those other two arms of the state. And that is a continuous battle that chairpersons will also have to ensure that exactly what you are talking about get the necessary attention. There's been numerous occasions where I know where the speakers that I've worked with over the years, after the chairpersons bring those frustrations to them, engage those relevant members who from the executive, and at times the committees engage the accounting officers that are there, why certain actions are not being undertaken. But we need to address the power relations between the legislature and the executive as far as this is concerned.
But I imagine that the separation of powers can't prevent the chairperson of a portfolio committee from saying to a minister or a CEO of an SOE or whatever, saying, this is what the committee or this is what the National Assembly said you should do by a certain date. You have not come back to us. to say you have done it, or you have not come back to us to say, I've not done it and these are my reasons. It may be that they might even say, well, I don't think that it's Parliament's job to dictate to me which of various solutions I should choose in resolving this problem. It may be that by virtue of the separation of powers, they could raise that to say, well, there are various ways in which this can be resolved. You as Parliament have said this is the way. I'm entitled to see it differently, and by virtue of the separation of powers, you must leave it to me. But at least they come back and report back to say, what have we done about it? And if they have not done anything and they refuse to do so, at least let it be known that they have taken the stand that they refuse. Or they might say, this is what we will do to address the issue, not the way you, as the portfolio committee, have said we should do it. But what should not be allowed, I would imagine, is a situation where a recommendation has been made by a portfolio committee and the National Assembly has approved that to say certain things must be done or should not be allowed to continue. And the executive just keeps quiet and the deadline goes by and they do nothing. I don't think that should be acceptable. At least if they disagree, they should come and say, we disagree. And then we know the executive and the legislature disagrees. But as I understand the position, in part from your evidence, in part from other witnesses' evidence, is it looks like very largely there is non-compliance with many resolutions, and that's the end. And it's not a situation where they come back and say, no, we have a different way of addressing it that we prefer. What would you say to all of those remarks?
No, Deputy Chief Justice, just in a brief response, and I tend to follow and agree with what you say, is that I must reiterate that there are a number of members of the executive over the years I have seen who does exactly what you are saying, to say that Parliament, you have made recommendations in this and that regard, or to the portfolio committee, but this is the reason why this or that cannot be done. But our biggest problem remains the issues of financial oversight and the remedial action that is required. And remedial action meaning acting against, and the accounting officer taking up that responsibility, acting against certain officials that through SCOPA reports or other reports are pointed out to have fallen foul of what they should have done. And that is a situation that needs to be addressed. And I would say that we cannot be happy with a situation where it is happening in certain instances, where a number of departments are responding to what Parliament say in terms of its recommendations. We need a situation that must be the standard and the norm. And for that to happen, we need the cooperation of everyone involved and the assistance of everyone involved. There's also, at times when you find these type of difficulties, where you would even engage through the leader of government business office to say that, but you know what, there is a certain ministry or department that there is certain things that are not happening the way it should happen, or they are non-responsive about certain things. So even that office gets engaged in various ways to address the situation, but the situation is certainly not what it should be.
Thank you. Mr. Freund?
Thank you, Chair. Now, you would agree with me, Mr. Froelich, that for every department, accountability rests in the minister.
Well, that is a point that that has been debated over the years. And they say when it comes to issues in terms of financial accountability is the responsibility of the accounting officer, which is the head of the department, and the minister is responsible politically for what is happening in their department. But the minister is the most senior person in terms at the political level who's in charge of the department.
Precisely. I, of course, accept that if one looks, for example, at the PFMA, if one looks at the responsibility of accounting officers and accounting entities, there are certain legal obligations where the buck stops with them. But the minister is accountable for the performance of all the accounting officers in the minister's department. Am I correct? Politically accountable.
The minister is politically accountable for what's happening in the department.
Yes. And in fact, our constitutional structure is that the executive is accountable to the legislature. Am I right?
Correct?
And the leadership of the executive is to be found in the ministers, correct?
Correct?
Now, would you go please to the reference bundle at page 32?
Yes.
This is part of the OVAC report, which you've told the chair was adopted by the National Assembly and the NCOP in 2009. Paragraph 4.1.9, sanctioning non-compliance by the executive. I'm going to read it into the record, the entire paragraph. It is recommended that Parliament develop rules to assist it further in sanctioning cabinet members for non-compliance after all established existing avenues and protocols have been exhausted. For example, naming the cabinet member by the Speaker of the National Assembly or the chairperson of the Council based on a full explanation. Would you agree with me that no such rules have been developed?
That's correct.
And would you agree with me that what this very recommendation indicates is that by no later than 2009, and in all probability long before that, the problem of executive failure to implement the requirements specified in House resolutions was a well-known problem. Assist in sanctioning cabinet members.
Advocate Friend, you broke up. I couldn't hear you clearly. Can you repeat that, please?
Would you agree that by no later than 2009, it was already recognized that it was necessary to address this problem by means of developing rules to enable the sanctioning of non-compliant cabinet members?
That's correct.
Could you perhaps venture an opinion as to why, as you have confirmed, no steps whatsoever have been taken to implement such rules?
Well, that is the responsibility of the National Assembly Rules Committee that is chaired by the Speaker of the National Assembly. And I cannot off the cuff give an opinion as to why that did not take place. We've had a review of the rules, and there is a committee, a subcommittee on the review of rules. They only met this morning again, who should be continuously seized with the implementation process of any decisions that has been taken in terms of the rules.
Well, let me put to you a similar question to the question put to you on a comparable issue by the chair. Would you agree that if the majority party, the African National Congress, as represented in Parliament, wanted this to have happened, they could have made it happen?
The majority party, together with all the other political parties, have a responsibility. But it is important for the majority party to lead these processes.
And if they'd wanted it, they had the capacity to bring it about.
As I said, I know there was a review of the rules with that edition of 2016 that you were looking at, and they're currently again in a process, that subcommittee of reviewing the rules. I do not have any explanation or reason why it was not done.
Yes, but Mr. Frolick, the question is, do you not agree that if the majority party was really committed to having it done, it would have been done? Just like they
I
are
agree.
able, just
I
like
agree.
they are.
I agree, Deputy Chief.
You agree? Yes. Okay.
Yes, thank you.
Thank you.
I think it's fair to the witness that I should convey something that was conveyed to me before
Yes.
the witness started to testify. And that is that the witness had other commitments for today, but rearranged his responsibilities. And I've been led
is
to
that so?
understand that he cannot continue beyond 6 p.m. this evening. Is that correct, Mr. Furlick?
No, thank you for bringing that to the attention of the hearing advocate friend. In fact, I've been on standby since Wednesday to deliver testimony in front of the commission, and I was not even sure, given the way that the proceedings unfolded, if I was going to give
Yes.
evidence today. I was supposed to be a speaker deployed by the African National Congress in Parliament at the funeral of Ms. Tozama Mantashe this morning. And I had to indicate, after discussions with advocate friend, who indicated that I will have to testify today, that I couldn't do it. Thus, I also have another commitment, Deputy Chief Justice, at 6 p.m. this evening, but I can probably go for another half an hour after 6 o'clock, if you will permit that.
Yes. So if we continue and stop at 6, you would be fine with that?
Absolutely, Deputy Chief Justice.
Yes. No, that's fine. I think we'll need to accommodate you because we have kept you waiting for some time. And if we don't finish, I'm sure arrangements can be made in the next few days, maybe, if everybody's available, for you to maybe come in either early in the morning or in the evening, an evening session. You know, we have these evening sessions, and on the basis of video link, as you are giving evidence today, so we could finish one of those days, of these days, maybe next week. But Mr. Freund would talk to you to check your availability.
I'm at your disposal, Deputy Chief Justice, as long as the arrangements can be made timeously,
Yes.
so that I can complete
Yes.
the testimony for which you want me here.
Yes. Okay. All right. Let's continue then until 6 o'clock, and then we release you.
Thank you, Chair. Chair, may I also, on the same issue, indicate that there are 2 further witnesses who have been waiting patiently, Mr.
Yes.
Gadzi and Mr. Smith, to
Yes.
testify today. It's my impression that we're not going to reach their evidence, and my suggestion that we should release them if they wish to be released for today,
Yes.
and
No,
make
no.
arrangements with them.
No, that's fine. We can release them. And maybe I should mention this to you, which I was going to mention later. The witness who was going to give evidence on Monday will no longer be able to give evidence because he is not well. So to the extent that you might be available to make use of Monday, whether during the day or or maybe evening session or both, that there is an opportunity to do that. So if Mr. Smith and the other witness, for example, are available, and if Mr. Frolick is available for us to finish with his evidence on Monday, we can look at that.
Yes, certainly, Chair. We'll follow that up after the conclusion of today's session.
Yeah, okay, all right.
Mr. Frolick, can I take you to some different topics? You deal from page 3 onwards of your affidavit with the various rules that regulate the powers and functions and duties of portfolio committees. I don't think it's necessary for us to deal with those in detail, because it's quite clear, is it not, that a portfolio committee has an obligation to exercise oversight, and for that purpose it has a power to summon any person to appear before it to give evidence, and to permit oral evidence and to conduct public hearings. They've got the powers they need.
That's correct.
Now, I want to explore with you the problem of what appears to be delay, and quite possibly culpable delay, in the legislature exercising appropriate oversight as regards allegations of state capture and corruption. And I want to deal with this issue in the knowledge that we all have that during June of 2017, you issued certain letters to the chairs of 4 portfolio committees, requiring them to, as a matter of urgency, commence investigations into then current allegations of state capture and corruption. Have I got that correct?
Correct.
And I want to make clear that I have no difficulty at all with the propriety of the letters that you sent. It seems to me to have been manifestly necessary at the time. But I want to make equally clear to you that it seems to me at least to be arguable that there was a culpable delay to do similar things much earlier. And I want to deal with that in a little bit of detail. Now, I want to read to you from Bundle 2, page 561. You won't have this, I don't think. I want to read to you the first couple of paragraphs of a headline article on the front of the Sunday Times.
One sec, Mr. Freund. Ask him if he didn't hear. Bundle 2. I think my registrar didn't hear you refer to the bundle for her to give it to me, but
It was
she...
Bundle 2, Chair, Bundle 2 at page 561.
Okay, all right, thank you. Thank you, Mr. Freund.
Thank you, Chair. I want to read to you, Mr. Frowick, from an article published on in the Sunday Times on the 27th of February 2011, under the heading, "Ministers Shiver," with that word in quotes, when summoned to family's home. The article says in the first part, "A revolt is brewing within the ANC and its alliance partners against the influence of the Gupta family over President Jacob Zuma and his government. The anger has become so widespread that some of Zuma's traditional backers are privately intimating that the controversy could hamper his bid for a second term as president. Members of the top ANC leadership structures, the National Working Committee and the top 6 party officials recently raised concerns about senior appointments that were being made in the government and at parastatals and the party's deployment committee was being sidelined, the Sunday Times understands that the Gupta's role in influencing the appointment of CEOs and chairmen in key state-owned enterprises was recently raised at an NWC meeting and will be formally discussed at its next gathering in a week's time. And it continues. What I want to put to you is, when allegations of that type are not only published in the newspaper, but are regarded as so serious that they should be discussed in repeated meetings of the National Working Committee of the African National Congress, is that not material that ought to have been the subject matter of oversight activity on the part of the responsible portfolio committee?
Well, Advocate, unfortunately, I do not have that article in front of me, and I was also not furnished with a copy. What usually happens is you will find that there's a lot of different stories and articles that appear in the different newspapers. You yourself make a reference to it, that in the article it is said that the matter will be discussed at the NWC and the NEC, but there was at no stage ever anyone or the portfolio committee who took the matter up to an extent where the committees will look at it. I will have to go back in my records of that year to see if indeed there were any portfolio committee or standing committee that further delved into that matter. But I cannot give you a clear response on what you are raising now.
All right. Now, let me put the question this way. Let us assume that the evidence shows to this commission that, for example, the Portfolio Committee on Public Enterprises did not raise that and did not seek to pursue it and did not seek to investigate whether, as published and apparently concerning to the NEC and the NWC, it is true that the Gupta's role in influencing the appointment of CEOs and chairmen in key state-owned enterprises, whether you think it ought to have been the subject of oversight by the committee responsible for the oversight of public enterprises.
Advocate friend, you know, over the years, I've seen in some instances, articles appear in certain newspapers. It's either inside leaks coming from within certain meetings that's going to take place in ANC structures and other. And I don't want to work on that assumption in terms of, as I've indicated, that I've not seen what you are referring to with now. But ordinarily, committees should be seized with issues, and whatever there is that any political party can propose an item to go onto the agenda of the different portfolio committees, and then they should have looked at it. But I don't want to arrive at any assumptions at this stage.
But I just want to check that I understand what you've just said. When you said they should have looked at it, that implies that if the information I'm giving you is correct, that is what was alleged and apparently alleged sufficiently to raise concern for the NEC and the NWC, you think it should have been looked at by the portfolio committee?
But you know, it's difficult for portfolio committees to deal with those type of sources where you have no clear indication as to where it is coming from, or anyone is not specifically prepared to come forward. It's nameless people who you can't put a face to. So what I'm saying is, ordinarily in the work of portfolio committees, if there were any instances or indications that there were things happening, then I would have expected that would have been formed part of the discussions of those portfolio committees. But not having seen the records of the meetings in this Public Enterprises Committee for that year or years, I cannot come to an assumption that indeed it happened or it didn't happen.
Now that I understand. Now, let me refer you again to material that you may not have. This is bundle 2, page 541.
I'm sorry, Mr. Freund. The don't forget your question. I just want to go back to this newspaper article to which you referred, Mr. Frolik. May I understand this, Mr. Frolik, that you accept that any member of a portfolio committee, I assume it might be more than one portfolio committees, that read this article and it seemed that there were matters, allegations made there which would be the type of allegations that his or her committee should be concerned about. Do you accept that any member of a relevant committee or relevant committees who read this article should have wanted their committee to discuss the matter and see what should be done about it, because the allegations were quite serious?
Deputy Chief Justice, I would say that any member of a committee, and as I say, I don't have the article, I don't know what it's exactly talking about, would have had an interest in that article.
Yes.
They would have had an interest in the article, and depending on how they approach the matter, would have or could have taken it to their portfolio committee.
Yes. Yes, no, that's fine. It's a pity you haven't, you don't have this, but as Mr. Freund said, you know, the headline was Minister's Shiva when summoned to family's home. And then it goes on to make allegations that the Gupta family was involved in the appointment of ministers and other functionaries. Of course, there could be some articles. I think nobody would say there are no articles that members of a particular portfolio committee would look at and say, well, it falls within our jurisdiction, but really it doesn't appear to be something serious enough. But certainly some articles might have allegations that are quite serious that committee members might want to look at. And I would think that if an article with such serious allegations came up, you know, if I was a member of a committee that has jurisdiction on those issues, I would certainly want these types of issues to be discussed. You accept that if it talked about ministers or people outside of government having, who have not been elected, having, and who are not the ruling party, having a say on the appointment of ministers and calling ministers to their home and ministers Shiva, that would be something that really should be of interest if it falls within one's committee.
No, I agree, Deputy Chief Justice. That's what I indicated.
Yes, yes. Thank you, Mr.
Thank you.
Freund.
Sorry, thank you, Chair. You also indicated, Mr. Frolik, that the committees have the powers they need. They can summon any person, and they have the capacity, if they wish to use that capacity, to investigate allegations of that type by requiring, if necessary, people to testify, if necessary, under subpoena. Am I right?
That's correct.
Can I ask this as a follow-up on that? I haven't had a look at the rules. I would imagine that the committees, portfolio committees, would also have power to require anybody to depose to an affidavit and say what they know about certain matters and send such an affidavit to the portfolio committee, even if they didn't come to give oral evidence. Is that correct?
So that is possible, Deputy Chief Justice, and that's why the legal services of Parliament is there to guide those committees in those processes.
Yes, thank you. Mr. Freund?
Yes, thank you. Just while we're on that question, there are rules that regulate the powers of portfolio committees. And one of those rules, I think it's referred to in your affidavit, is Rule 227. And it says a portfolio committee may monitor, investigate, inquire into, and make recommendations concerning any such executive organ of state and so forth. So they have that power, they have the authority to make such investigations. You would agree with that?
That's correct.
And there are other rules that regulate not only portfolio committees, but all parliamentary committees. And you might know the rule far better than I do. Can you just point me to the rule that confers the relevant powers?
Rule 167.
167. Chair, it's at page 286.
Of which bundle?
The legal bundle, Chair. That's the bundle that
The
has
legal-
only two sets.
Okay. 256.
286
Okay.
in the legal.
I've got it, thank you.
Yeah, and it says as follows, under the heading General Powers, for the purposes of performing its functions, a committee may, subject to the Constitution, legislation, and the other provisions of these rules and resolutions of the Assembly, A, summon any person to appear before it to give evidence on oath or affirmation, or to produce documents. And then C, permit oral evidence and so forth. So they have those powers. I think you would agree.
That's correct.
Now, you said a moment ago, and I agree with you, that issues of this sort, if they came to the attention of a member of a relevant portfolio committee, would be such that any member would be entitled to raise a concern about that issue in the portfolio committee and request that it be addressed. Am I right?
That's correct.
And if such a request were made in relation to allegations of that type, do you agree with me that the responsible decision, given that there is a constitutional obligation to exercise oversight over the executive, would be to accede to such a request and to conduct such an investigation?
That is the powers of the committee as we refer to in 167.
Yes, now I know they have the power, but I'm asking you a different question. Should they not, in that scenario that I have painted, let's consider it for the moment an academic scenario, a hypothetical scenario, should they not, as a matter of political responsibility and legal responsibility, exercise the power to conduct such an investigation where such a matter is drawn to its attention and where a request is made to please exercise your powers and to investigate and, if necessary, summon witnesses?
You'd expect the committee to do so. The committee, what usually happens at the front is that when a certain member raises something and they want it to be added to the agenda, the committee deliberate on the matter and they decide when to and how to proceed with the matter.
And with allegations of the type that we've just been referring to, the responsible decision would be to investigate.
That's correct.
Now, and Mr. Froelich, it does appear to me that we're not going to finish your evidence today, if we're going to. So, in fairness to you, we will make arrangements in the same way as we did last night with certain other material, to transmit to you before you next testify copies of documents to which I'm now referring. But I've referred to one press article you hadn't previously been alerted to, and I want to refer now to another such article. And if you feel after having read it when you come back that I've been in any way unfair to you, then you can raise it and we will deal with it at that occasion. But for the moment, I'd like to refer you to page 541 in Bundle 2, which you won't have, but this is part of the affidavit of Ms. Ranto, who has testified. I don't know if you had an opportunity to watch her evidence.
Advocate Freund, I watched some part of evidence. I didn't watch everything that was happening on that day.
So in paragraph 8.13 of her affidavit, she's talking about the situation as pertained by March of 2016. And I want to put to you that in my mind, that's a critical moment in history, March 2016. And she says, by March 2016, a host of allegations have been made public, including the following. These Jonas' claim, reported in the Sunday Times on the 13th of March 2016, and confirmed by his public statement of the 16th of March 2016, that the Guptas had offered him a 600 million rand bribe in October 2015 if he would take the post of finance minister and do their bidding, which he said he had refused. An allegation that the person then appointed instead of him as the new finance minister in early December 2015, Mr. Des van Rooyen, was accompanied to his new post on his appointment by Gupta-linked aides. Peggy Mentor's allegation during a radio interview that in 2010 she had been offered Barbara Hogan's job as Minister of Public Enterprises by the Guptas if she cooperated with them in assisting Jet Airways to replace SAA on the Mumbai route, and Barbara Hogan's allegation that there were definitely sinister forces operating behind her back when she was Minister of Public Enterprises until October 2010, and that she too had faced pressure regarding Jet Airways. You will recall those incidents and allegations at about that time, am I correct?
I recall some of it, Advocate Freund.
Now, would you agree with me that by that time, if the Portfolio Committee on Public Enterprises received a request that there should be an inquiry within that committee to inquire into whether there was truth in these allegations and other allegations referred to in the evidence of some of our witnesses thus far, the responsible and appropriate response should have been to accede to that request and to agree to conduct such an inquiry within the Portfolio Committee.
Well, Advocate, as I've said, I've watched part of the testimony of the Honorable Ranto, and I have not been furnished with the material that you are referring to at the moment. But given the background that you have given to, then it would have been something that the committee should have been seized with.
Should have been seized with. And does that mean should have investigated and utilized its powers to try to get to the bottom of?
Well, depending on how the committee wanted to proceed on the matter, because also in terms of Rule 167 and Sub-Rule F makes it clear that the committee can determine their own working arrangements.
Yes.
So it was entirely in the hands of the committee to decide how they wanted to proceed.
Yes, I accept that. And I want to make clear that not only do I accept that it is not your function as the House Chair of Chairs to substitute your judgment for their judgment. They're entitled to make a judgment. I accept that. But what I'm asking you is what judgment you think they should have made. And I think you agree with me from what you've already told me, that you think that if they were acting responsibly, they ought to have agreed to investigate those allegations. Am I correct?
The committee should have applied their mind to the matter and should have decided what would be the best way to proceed with that matter in the absence, as I've said, of the material that you are referring to.
Yes, it seems that it would be better that you know exactly what material was before them. Is that correct? Mr. Frolick?
Can you just repeat, Deputy Chief Justice? I couldn't hear you clearly.
Yes, I'm saying, it seems from what you are saying that you are reluctant to pass judgment or to say what they should have done without knowing what material was before them. But if you were to
Correct.
be given the same material that was before them, then you can take a view as to what the responsible thing was that you think should have happened.
That's correct, Deputy Chief Justice.
Okay, all right. Mr. Freund?
Chair, that being the case, and it being 5 to 6, I would be amenable, should you feel it appropriate, to take the adjournment now.
Yes.
Alternatively, I can proceed with certain
No,
issues.
that's fine. I mean, 5 minutes is not going to make much difference. Okay, let's adjourn, and then once you have, Mr. Freund, had a chance to talk to witnesses and look at your own availability about Monday, you'll let me know during the weekend.
Yes.
The earliest you can let me know, the better, because in case you are not able to use Monday, there is a possibility another evidence leader from another work stream might be able to rearrange their program in such a way as to be able to use Monday as well. But I accept that it's short notice, so it might not be easy, but you'll just do the best you can.
Yeah, I would think that there's a reasonable prospect from my side that can be done. I have other commitments for Monday, but I'm hopeful that can be rescheduled.
Yes.
And so it'll be a matter of checking with the witnesses.
Yes.
And I will communicate with the structures of the commission, hopefully in the course of tomorrow.
Okay, no, that's fine. But also, to the extent that the day session on Monday might not, you might not be able to use it, then the possibility of looking at some evening sessions next week, that must be kept open if all consent would be available, so we can try and do as much as possible.
Yes, Chair.
Yeah, okay. All right. Thank you very much, and thank you to everybody that we have been able to sit until this time. We are going to adjourn, and then on next week, from Tuesday at least, I think up to the end of the week, it will be evidence relating to ESCOM that the Commission will be hearing. This is just for the benefit of the public. I'm making the announcement for the benefit of the public. We adjourn.
Can I just keep online for the moment, because I see that Mr. Smith is, I think Mr. Smith is still here and Ms. Magadzi is still here. Would it be possible for both of you to be available on Monday? Is that Mr. Smith?
Thank you, Advocate. It is